The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, please be seated. We'll begin this morning with United States versus Cox, and Ms. Leaston, it'll be a pleasure to hear from you.
Thank you, Your Honor. Good morning, and may it please the court, Jenny Leiston for Roy Cox. Your Honors, the district court erred in classifying Mr. Cox as a career offender, and the government cannot meet its burden of showing that that error was harmless. So first, as to the error, Mr. Cox's prior Florida conviction for trafficking in cocaine is not a controlled substance offense under this court's well-established precedent. The offense is overbroad because it includes conduct that is not covered by the controlled substance offense definition. Specifically, the Florida trafficking permits conviction based on purchase and possession of cocaine, but does not require the jury to find intent to distribute, as 4B1.2 requires.
Well, there's no dispute about that, is there?
There is not, Your Honor.
I mean, it's pretty clear that a controlled substance offense doesn't involve purchase or possession, and yet the so-called predicate here allowed conviction based on purchase or possession, so it was considerably broader, and that's understood. But the difficulty for you is, as we both recognize, that the district court said, well, if they're sent back to me, I'm absolutely going to impose the same sentence as I did before. And so the question arises, is a remand simply a useless jump through hoops?
Absolutely, Your Honor, and I just wanted to start out with that to get us all on the same page. I just wanted to make sure that there were no questions in the wake of the 11th decision in Roe. But I think if we're all on the same page, this was absolutely an error. We can certainly turn to the harmless error question, which I do think is the main issue here. And so to establish harmless error, and again, the government does have the burden here of showing that. And what we're talking about is then the government has the burden of convincing you that the district court would have reached the same sentence, that sentence would be reasonable. And as this court said in United States versus Shivers, the burden is on the government to show that the error did not have a substantial and injurious effect or influence on the result. And I think that...
Can't we, aren't there instances where we can take the district court at its word?
So I think the burden here for the government...
That's particularly the case where the difference that we're talking about was, what, 4 months or so? It was a relatively small difference, a relatively small upward adjustment from what you had requested?
No, Your Honor, I don't think that's true. That was an alternative. There was an alternative request, but what we were saying, in order to show harmless error, the government, first of all, has to show you that that career offender designation didn't have any injurious influence on the result. There are a couple of factors at play here that I think makes it difficult for the government to meet that burden. First, you have such a wide divergence between the correct range and the erroneous range, right? So we're not talking about just a little 2-level enhancement that upped the guideline range by, a couple of years. I mean, this was a significant gulf between the correct range and the erroneous range. And every time, and basically the court said, I'm compromising, I'm anchoring my decision I'm giving you what's in the middle of that. So he obviously anchored that sentence to the erroneous range, and every time He mentioned the alternative variance, which must be both substantively and procedurally reasonable. The only thing he mentioned was the career offender guideline. Every time. So
Why isn't that like totally the right way to think about this, right? Because we've got guidelines that are not binding, right? They're like, indeed what the word says, they're
Yeah.
guidelines.
That's right.
And so you might well say, if you were a district court judge, which seems like what the district court judge is saying here, is whether you are technically a career offender or not, in my sense, you are actually a career offender. And, you know, we may understand that under the technical rules here, this is not a controlled substance offense, but he can make the judgment that, like, effectively you are. You are no worse than the person that was convicted of the same offense that has a intent to distribute element to it. And so I sort of think that you sort of are like a career offender, and so I can take account of if you were technically a career offender, you'd be here. If you technically weren't here, but I'm actually not judging your sentence based on technicalities. I'm trying to take the measure of the man. And in doing that, I can sort of like say, listen, whether you're technically one way or the other, this is the right sentence. Why isn't that like exactly what district court judges ought to be doing, rather than getting all wrapped up in these technicalities about what qualifies under the modified categorical approach, whatever in the world it means?
Right. So the difficulty, I think, is that, so let's imagine that the court did not make this mistake, that Mr. Cox was never designated a career offender. Do we really think the court would be making that same assessment and thinking that Mr. Cox, his
Absolutely, right? So if the
his
district court went the other way and said, I now have thought about this more, I find he doesn't technically qualify as a career offender. But if he did, which he in reality is a career offender, it's just not technically a career offender, his guidelines would be up here. And so I want to sort of think about both sets. Like, that seems like exactly what we're asking district courts to do. Like, consider the technicalities, and we demand that you do these like uber technical decisions to decide the right guideline range. Maybe that's like required, but once you do so, you can also say, listen, we know for reality's purposes, the measure of the man here is that he is a career offender. He is technically not one, but the measure of the man is, and so I'm going to take that into account. That seems like exactly what we want district courts doing.
And my argument would be that is just, he's not a career offender, and that to tie that sentence expressly to the career offender guideline and repeatedly just refer in the alternative variance
So
to
your
the
view is
career offender guideline.
that would be an impermissible thing for a district court to do. A district court to say, this second-degree murder charge is not a crime of violence under the technical rules, or this trafficking offense is not technically a controlled substance offense. And so I find that it's not a career offender. But I'm going to look at what he would have been, what his guidelines would have been as a career offender, because I think the measure of the man is he is a career offender, even though technically he doesn't qualify. You think a district court judge is prohibited from doing that?
No, I'm not saying he's prohibited. I'm simply saying that it's more difficult for the government to meet its burden to show that career offender, erroneous career offender.
Are you contending that the alternative sentence would be unreasonable? The alternative sentence seems to be a perfectly reasonable one.
No, I do think the alternative sentence is also both procedurally and substantively unreasonable. When you look at the criminal history here, I mean, under the technical rules here, the instant offense probably doesn't qualify him as a career offender, no problem. But when you look at the overall picture here, the criminal history includes criminal offenses of distributing cocaine and possession with intent to distribute, and all of the way, and then the career offender. When you look at
at the total history here, all the questions about the dividing line between possession and purchase on the one hand and distribution on the other hand, that's what makes him not a career offender, is because there's this line between possession on the one hand and purchase, and then distribution on the other hand, which we think is a more serious offense. And then when you start looking at the criminal history, that line disappears because there are there are a number of convictions here for distribution. He's not just, at the end of the day, he is not just a possessor. He is not just a purchaser. There are offenses for distribution and intent, possession with intent to distribute. And so the whole dividing line that makes the career offender an erroneous technical adjudication disappears when you look at the totality of the picture.
And so if this panel is convinced that the sentence is procedurally and the alternative variant sentence is procedurally and substantively reasonable, and that the career offender that the alternative variant sentence is procedurally and substantively reasonable, nonetheless, that the error here still had an injurious effect on the result because of the continuing harm of the career offender designation.
No, but if we
Wait, explain that.
The whole purpose of the Gall decision was to accord the district courts a place of primacy in sentencing. And if we don't take the district court at its word here, and we fail to recognize that at the end of the day, this person is not just a possessor, but he is a distributor. And if we don't take the district court at its word with these circumstances, aren't we running counter to what Gall wanted to do, which was to preserve a measure of discretion and primacy in sentencing and have that reside with district courts?
And so what I was trying to say, Judge Wilkinson, is this career offender designation is nonetheless harmful because it will harm Mr. Cox in the future. It renders him ineligible for any future guideline amendments, retroactive, and it will raise his guideline range at revocation. And so what I'd like to do is talk about this court's decision in United States versus Charles, because the government has brought that up in its reply brief. I actually think Charles is quite a good decision for me because it shows that this court will consider potential harm beyond just the sentence that is the term of imprisonment.
How will it harm him in the future if the opinion makes clear that the career offender designation was technically erroneous? We wouldn't have to say assuming arguendo. We could say the career offender designation was in error. And if the court explicitly says it's in error, how is that going to be harmful to the individual's future when the error is mentioned and conceded?
And so if that is this court, if this court will actually reach the merits, because a lot of times under assumed harmlessness, this court declines to even reach the merits and just says, well, we don't need to talk about the merits.
So what you're asking us to do is, because of the future and not harming this individual in the future,
Yeah.
you're asking us not to say assuming arguendo. And that seems to me a very fair request in light of your representation of your client. That resonates with me. And a lot of times you're right. We move right on to harmless error by by virtue of saying assuming arguendo, and you're asking us, please do not do that here.
I am, Your Honor.
What, can you just help me understand? I want to
Yes.
make sure I understand the argument here. With respect to the revocation proceedings?
Yes.
Why do you think that that a future court would be bound by the prior court's decision with respect to what the criminal history category is?
Because because the criminal history category, he is in the judgment is now a 6 by virtue of the career offender designation. That's what it says in the judgment.
And you think even if there was intervening case law, but not our decision, right? Imagine we just punted on the question. You think that the future district court is bound by the prior district court, even if there have been changes in the law since that happened?
I think the probation officer is going to look at that judgment, says he's a criminal history category 6.
I know,
that's never been corrected.
But that's what the probation officer is going to do. But the judge, the revocation judge, I mean, I get we're now talking about your client has gotten out of jail and violated his terms of release. Whether that is a basis for us to reach this seems crazy to me. But the judge is not bound by it, right? The judge who gives the revocation sentence is not bound by the old criminal history determination.
Again, if this court makes clear...
No, I'm talking about if we don't reach it at all. We
If
just
you don't
assume
reach it at
error.
all,
You think they're bound.
If you don't reach it, the district court is going to assume that it was correct.
No. You have to say that it's bound by it, not that it will assume it was correct, right? You have to say it's bound, because my point is the revocation judge has to make its own decision about what the criminal history category is, and the defendant can object to it, and he's not bound by the prior judge's decision.
Why would the judge make a different decision if this court has not reached the merits and says...
And if the district judge gets, in your view, if the district court gets it wrong in that instance, you have a right to an appeal, right? Just like everything else. But the decision here doesn't affect that decision. It's not a legal limitation on that decision.
I mean, the way the revocations work is that the probation officer is just going to give that guideline range. I agree. Yeah, we could make a whole nother argument. We
Right.
could go through this all over again, I suppose, at a revocation hearing.
But you want that, I mean, your argument is you want us to do that, not because it's necessary if we think there's harmless error, but to resolve it in your favor for future criminal conduct?
Yes, and for also to just make it clear to BOP that he's not a career offender, and to make it clear that he would be eligible for any future guideline amendments. If that is all the relief that this court would be willing to give,
But
we
aren't
are
all of those
satisfied
things
with
like just
that.
totally speculative, right? Like what the executive does or doesn't do is like beyond us, right? We talk about this with respect to where they're housed and how BOP treats things. That's just not our problem. So what do you think Charles tells us that we have to consider what BOP might do based on what the criminal history category is?
I'm saying that the government has the burden of showing that this error was harmless. I'm simply pointing out the harms that are likely to occur if the error is not corrected.
But so you think the harmless error evaluation for us includes harm that other judges in the future may assign to the district court's career offender determination? I mean,
Or-
isn't it, harmless error is with respect to the decision, yeah, the sentencing decision here, isn't it?
Your Honor, I see I'm past my time. May I answer, Judge Wilkinson?
Sure.
Thank you, Your Honor. It is not limited to simply that. And I point to Charles, because in Charles, this court actually did send the case back to the district court to determine whether the defendant might be eligible for relief under the First Step Act.
But that was relief at that point, right? And what Charles says is, What we don't do is engage in unrealistic speculation about the possibility of some future harm by some other actor, right? That's what Charles is telling us not to do. Don't think about what BOPs might do or might not do. Don't think about what might happen when this defendant commits another offense or violates his supervised release. Like, those are the speculation that Charles tells us not to consider.
So I have to disagree, Your Honor, because Charles is very, very fact-specific. And if Charles actually said that, it would have been very easy for
I'm quoting, must not engage in unrealistic speculation about the possibility of future harm. Like,
And-
that's a quote. It's
Yes.
it's not fact-specific, like, that's the
Right.
quote.
Right. Charles also is very fact-specific. Judge Niemeyer was very careful to extensively say over and over again on these facts, under these circumstances. And again, also, let's make clear, it was the defendant's burden in Charles to show harm. It wasn't the government's burden to
But
show that the
there's
harm
no-
was
There's no
harmless.
speculation if we do what courts do a million times during a term, which is to say, yes, there was error here, but it's harmless. And there's nothing in Charles Charles prohibits speculation, but it doesn't prohibit a court from acknowledging an error as part of its duty of exposition. You see what I'm saying? It doesn't prohibit us from acknowledging an error
Right.
as part of our duty of exposition.
I agree, but I'm also simply saying that Charles, the only harm
We don't
that
have
the
to, we don't have to say why. We don't have to say whether we're doing this because we're speculating or anything like that. I don't think I don't think that we're required to speculate in any case that we find an error. But all I'm saying is that we owe a certain duty of exposition to the public, and sometimes that requires acknowledgement of an error. It doesn't require us to speculate about harm down the road or what is it? It's just a product of our obligation to explain what we are doing and why. And the reason why we are doing this is because this is not as the sentencing guidelines make clear, this is simply not a controlled substance offense for purposes of the career offender statute. And that's all that needs be said.
And if this court is willing to say that in an opinion, that we would be satisfied with that, Your Honor.
Okay.
Thank you, Your Honor.
Mr. Pugh?
Good morning, and may it please the court.
Conceded the error. Do you have any objection to the court as part of its, the discretion that we have to explain ourselves in the terms that we wish to explain ourselves, to acknowledging that there was that there was an error here, and saying that this was a controlled substantive offense?
Your Honor is right. We're not contending that this was not an error. I think that's foreclosed by Brandon. I think if the court had any reservations, it would be based on the fact that this area of law is in flux.
But do you have any objection to what your opposing counsel suggested? Do you have any objection to that? You've conceded the error?
We have conceded the error.
Yeah, but do you have any objection to our, I can't imagine what it would be. We don't need to speculate, but it is within our discretion to say that there was an error here.
Your question, Your Honor, is to acknowledge the error versus to assume an error?
Pardon me?
I want to make sure I'm understanding your question correctly, Judge Wilkinson. No, we would not object to that. I think the reservation there would be that the field of law is in flux, the 11th Circuit, only after our briefing switched course on it. So if the court elected instead to wait until the decision was necessary for a case, I think that would be a very viable path. But if the court...
Your point with the Charles side is, we're not required to do it. These sort of speculative future harms don't require us to reach the merits.
Absolutely,
And
Your
find
Honor.
us an error. But your point is, with respect to Judge Wilkinson, the pragmatic arguments that he's made for reaching the merits, you sort of defer to the court, because the court is entitled to make those decisions. Your argument is the court doesn't have to do that. Charles tells us that this future violation of supervised release, these potential future harms that are speculative, those are not enough to create a harmless error problem. It doesn't mean that, we don't have the discretion to reach an error rather than assume it.
That's absolutely correct, Judge Richardson. And I agree that with regard to this revocation problem, we have a speculative revocation in the future. We have this idea that the probation office and the parties...
We would have every right, as my fine colleague suggests, we would have every right, if we wished, to say, assuming arguendo that any error occurred. We don't, obviously, and I think Pearson v. Callahan and a number of other decisions are beginning to give courts of appeals more discretion. You look over in the qualified immunity context, we have discretion as to whether we want to reach the qualified immunity point at first, or whether we want to reach the constitutional violation point first. And all I am suggesting is a terribly modest thing, which is that it is within our discretion to indicate that the error that an error was made. It's within our discretion. It has to be within our discretion to say that an error was made, but we cannot be required.
I absolutely agree, Judge
Or
Wilkinson.
prohibited in some way
I think that's exactly correct.
from assuming arguendo. We absolutely have the right to assume arguendo. The question is, should we? And that's a discretionary call for the Court of Appeals, is it not?
That's correct. Yep. I believe that the court does not need to reach it for the reasons that have been discussed, but it can.
I don't think we need to reach it, but the question is, she's made an argument that we should. I don't think that argument is frivolous. And so I know it's a perfectly logical thing when people sit behind these different tables to disagree, but, it's not unheard of when two people recognize that there's an area of agreement.
I agree, Your Honor. I think it's within the court's discretion. I think there are some countervailing reasons to perhaps wait, but we have no objection if the court was inclined to go forward with that.
Can you address your colleague's argument on the sort of what I'll call maybe the more core harmless error, like whether the sentence was actually harmless? I don't want to misrepresent her argument, but I take at least part of her argument to be that we shouldn't find it harmless despite what the court said, because the court indicates the sort of anchoring use of this higher guideline, and by referencing and using the incorrect guideline as an anchor or reference point, that shows us that it has some sort of effect on the ultimate sentence that was given. Can you sort of respond to why you think that's not correct?
Absolutely, and I think there's two pieces to that. There's what the district court did, and there's what is not present in this transcript. If we look at some of the cases where the court has found that there did not apply harmlessness, we see, for example, in Green 2021, the court noted there was no record evidence showing the district court's 144-month sentence was imposed independently. In Gomez from 2012, nothing in the record suggests the district court would have varied upwards to arrive at a 24-month sentence. Or in Shivers, which opposing counsel cited, the government actually specifically asked if the court be willing to find the same sentence, to state that the same sentence would apply without the enhancement. It declined, and the court noted where it is unclear whether a district court would impose a lower sentence, courts have erred on the side of remanding for resentencing. So we don't have those facts here. Now, what do we have? We have, as Judge Richardson, as you described, we have a district court that is taking the measure of a man, and this district court, as many courts have, has expressed some frustration with career offender and noted that the approach does not involve the defendant in front of me, noted that it does not involve what the person actually did. Nonetheless, in noting that there were these 2 prior cocaine convictions, the district court mentioned.
Well, part of the reason it's harmless, it seems to me, there's a fundamental reason about leaving district courts in a primary position, but then there's also the reason that the 120-month sentence is perfectly reasonable. It is a substantively reasonable sentence. It's not that much of a variation from what was requested or what the guidelines show, but where the district court says, I'm going to do the same thing, and where the thing that he did was substantively reasonable because of all of these predicate offenses involving distribution and possession with intent to distribute and everything, why wouldn't that be harmless? I mean, how could it be anything else?
Absolutely, and that is our position, and I think that overlaps with the point I was about to make. The district court, it mentioned career offender as it went on the sentencing, but if we look at the context, the district court stated the career offender guideline is intended to capture the increased likelihood of recidivism, and he stated that his sentence falls within the intent of the career offender guideline. He's not anchored to it. He's noting that career offender, as many statutory schemes, as many parts of the guidelines, just emphasize that when someone repeatedly commits violent crimes or repeatedly commits drug distribution offenses, that there is an increased risk of recidivism there.
Well, I would think that it is actually, from the standpoint that you're arguing, it would be, you could look at this from the government's standpoint as being advantageous when a court recognizes, rather than just assuming arguendo, but recognizes an error and yet proceeds for a variety of reasons to hold the error to be harmless. And that seems to me, in fact, a stronger argument for harmless error than if we just slide over it and say, well, this is assuming arguendo. It provides a clear illustration of where there was a plain error or an error, and yet the court still, for various reasons, found that to be harmless. And that, I think, bolsters the importance of harmless error analysis when we're dealing with district court sentencing.
I'd agree that harmless error analysis is most critical in that scenario where the court does conclude that there was an error. I think either way, how the court wants to proceed on this Florida trafficking conviction, in this case, we have harmlessness here. The district court's decision is very well explained and thoroughly. Had this been an appeal simply of an upward variance from that range, I think there could be little question that that would be substantively reasonable. I would also note that if the court looks at the entire transcript of the sentencing and sets aside the portion where career offender specifically was discussed, this frankly reads like a transcript of a sentencing going from that 84 to 105 guideline range. In fact, as soon as the district court made that ruling, it stated, this ruling in no way precludes an argument under 3553 that the other guideline range may result in a more warranted sentence. That's at JA 55. And the government, having already filed a motion for upward variance from that lower range, proceeded, despite this ruling, to argue, I think in its first sentence, that upward variance from that lower range was reasonable. Defense counsel, both in their initial statements and in rebuttal, talked about that range ultimately backpedaling to to the request that the court take that range, bump him up to 6 based on the recidivism risks, and then impose a sentence of 115, only 5 months less than what the district court ultimately imposed here. This was an imminent reasonable sentence based on an entire hearing that was discussing an upward variance from that lower range.
All right, do you have anything further? I'll ask my colleagues if they have further questions of you, Judge Richardson. Judge Quattlebaum.
All right, thank you. Seeing no further questions, we'd ask that
We
this
have
court
no further
affirm.
questions.
Thank you.
You, Ms. Lyson, you have some rebuttal time.
All I would like to say, Judge Wilkinson, in favor of a decision that actually reaches the merits of this issue of first impression in this circuit, is that it would also be very beneficial, obviously, to the circuit to have more guidance on this issue, and also to the district court so that he doesn't make this mistake again in the future.
But I'm not interested in going into how beneficial it would be or how beneficial it wouldn't be. All I'm saying is that there's sometimes that I feel more comfortable when a court doesn't glide over that and is candid in the fact that this was an error based on our precedents. We're not afraid to acknowledge that. And I think it makes the case down the road for harmlessness even stronger when you acknowledge the error and say, but no remand. And so,
We would ask this court to actually reach the merits. If this court is inclined to grant a non-harmless error, to not avoid the merits of the decision.
Assuming we're going to do that, can you sort of just summarize why you think the 11th Circuit gets it wrong?
So the 11th Circuit is just on the other side of a well-established circuit split. The 11th Circuit does infer intent to distribute based on a statutory presumption with quantity. The 4th, 5th, 6th, 9th, and 10th Circuits fall on the other side of the circuit split. And so you've got Brandon, you also have all the other, this court's all the other precedent that says with the controlled substance offense definition is different from the ACCA definition. It's much tighter, and unless that intent to distribute is in the statute, unless the jury has to find intent to distribute, it's not a controlled substance offense in this circuit.
I see that you're court appointed, and I want to thank you very much for your arguments. You've done a fine job, and we really appreciate it.
Thank you, Your Honor.
We'll come down and Greek Council and move directly into our next case. Right here, we're going to move right into United States versus Speed, and Mr. Roots, we'd be happy to hear from you remotely, sir. Whenever
All right,
you're
well,
ready.
thank you, Your Honors. May it please this honorable court, my name is Roger Roots. I represent the appellant, Mr. Hatchet Speed, And I would especially like to thank the court for allowing me to present this argument by remote connection. I'm 2 time zones away, and I very much appreciate it. Thank you. Mr. Speed, of course, was wrongly convicted of possessing 3 so-called quote-unquote firearm silencers, which were not firearm silencers. In fact, these devices were purchased absolutely lawfully at the time. Of course, we recognize that the U.S. government later moved against the manufacturer civilly and took those off the market. But Mr. Speed simply purchased products that are solvent traps or gun cleaning drip containers, essentially. And these devices were in his in the original packaging and plainly marked solvent traps. And yet the government pursued this case as a firearm silencer possession case. And I would say, in some ways, the trial was fundamentally unfair, just in so many ways. We stand on all the arguments we've made in all of our briefs, but I'd like to just focus on the unfairness of the trial, just on the basis of the law of evidence. In some ways, it was despicable. The government essentially basically let the jury hear all these horrific, statements that had been secretly recorded by a false friend, an undercover FBI agent who was wearing a wire while he, using leading questions, he got Mr. Speed to make all kinds of, odd statements about the future Civil War collapse and the war between Jews and Christians. And after some leading questions, this undercover FBI agent asked, "Well, is that the purpose of these solvent traps?" And he, I think, Speed responded, "Yeah, something like that." And yet, so the jury was, I think, all of us are human beings. We are likely to convict someone who expresses horrific, ideas, just on that basis alone. So the trial was poisoned, and the jury was fundamentally deceived because it was not his true state of mind, and the district judge excluded from the jury the evidence that proved Mr. Speed's innocence, that proved Mr. Speed's innocent state of mind, wrongly calling that evidence, quote, a mistake of law evidence, and suggesting that mistake of law evidence was somehow improper. And of course, in specific intent crimes, mistake of law evidence is absolutely a proper defense. Mr. Speed had told this same undercover FBI agent, quote, "Once you drill a hole in the end of these solvent trap containers without filling out the Form 1, that makes you a felon. You're a felon." Okay, so the judge ruled with the government that was mistake of law evidence, and that was not allowed. Of course, according to a long line of cases, for a specific intent crime, a mistake of law is a valid defense. And I go back to the language of the statute. Of course, this crime is described in 2 different titles of the U.S. Code. It's relevantly complicated, but the definition of a firearm silencer is either a device for silencing or muffling the report of a firearm, or a combination of parts intended for use in assembling a silencer. So that phrase, intended for use, makes this crime, this allegation, a specific intent crime, and mistake of law is plainly a defense. And Mr. Speed was robbed, the jury was robbed of hearing the actual evidence of Mr. Speed's innocence. And instead, the district court pretty much instructed the jury that it was almost a strict liability offense, that mere possession of these objects was almost strict liability. And then to shoehorn this horrific, this undercover recordings of him talking about the Jews and the Christians and post-apocalyptic Armageddon or whatever in the future, which was absolutely conditional and irrelevant in most ways, and using that against him to poison the jury This was just an improper conviction. I would say that these devices, the way Mr. Speed was convicted of possessing these 3 containers is not just a first impression in this court. It's a first impression in the United States. As far as I can tell, no one in America has ever been convicted of possessing objects that could be categorized as a combination of parts intended for use in assembling a silencer, where it would require actual drilling, actual modification and alteration, not just assembly. And so I would say just the plain language of the statute did not apply. The statute plainly did not apply to things that need drilling or altering or modification of this kind.
Counsel,
And
do you
so
think it
Mr.
would have been,
Speaker, just-
counsel, do you think it'd have been different if it had been like a snap? So in other words, if it hadn't required a drill, but there just was a screw that was screwed into the, the location where the bullet would come out, one might say. But instead of having it marked for a drill, there just was, excuse me, there was a screw that could be undone with your fingers. Would that mean that because that would require modification, that would preclude such a conviction as well? I think your argument is yes, but I just want to make sure I understand.
Well, let me think about that. I would have to say that would fundamentally change the question. I think the answer is still false because it would require modification. But there you would actually have the parts that could be assembled or clipped together or whatever. In Mr. Speed's case, he didn't even possess a drill press. Had never altered anything like this. In fact, he had a record of 100% total compliance with the strict requirements of the National Firearms Act. He had a record of purchasing lawfully registered silencers. So in this case, he not only did he not have the drill, but he said something like, well, in the event of this civil war or whatever, entirely conditional post-apocalyptic, you might say, ramblings in confidence, in total privacy to a friend, albeit it turned out to be a false friend. He admitted he didn't even have he didn't have many of the components that would be needed. They never found a drill press, a drill bit, by the way, which is not a normal drill bit that you could buy normally in a drill kit. It would be a hardened steel drill bit, an Allen wrench. He had never seen it done. No discussion of ever intending to immediately do it. It was just this contemplation of a future societal collapse. And, in response to a leading question, he said, yeah, oh yeah. Well, I mean, it's just so remarkable that that we're here on appeal. To me, just the insufficiency of the evidence alone requires reversal here.
Can you at least for a
I would
moment,
also add,
counsel, at least for a moment,
Go ahead.
I understand you want to talk about the evidentiary challenges, but will you at least address for a moment the Second Amendment argument and help me understand why you think a silencer is a component that falls within the definition of arms? There are lots of questions that follow that, but that's sort of the predicate question before we really get to talk a whole lot about the Second Amendment. Why is it that you think a silencer is such a component that qualifies as an arm as opposed to something that does not qualify as an arm?
well, I argue these were not arms, but if they are arms, they are protected under the Second Amendment. The Bruin court was very broad, really. In the wake of Bruin and Heller and these other cases, the U.S. government has been essentially arguing that, well, those courts just said that all prior federal gun control laws are constitutional because they've been on the books for a period of time, 20 years or more.
Well, a firearm can.
And that is not
Counsel,
what the Supreme Court
counsel-
said in Bruin.
the firearm is perfectly operable and without a silencer. The silencer is almost by way of attachment, is it not? It's an accessory, but the firearm itself is perfectly operable without the silencer.
Sure, but I mean, you think about other things, a holster, magazine clips, all of those things are accessories. You know, those are part of arms. Those would fall into the category of arms.
So your
of course-
position, I take it, counsel, is that it need not be strictly necessary to the firearms operation in order for it to be a component that is protected by the Second Amendment.
Sure, absolutely, yes. I mean, clearly, it's difficult to imagine a hunter or anyone possessing arms going out into the field who doesn't also have lots of accessories that really are part of the operational, so-called bearing of those arms.
And I take you,
as the Second Amendment talks about.
so do you think like a magazine is an example? Obviously, a firearm can be used without a magazine. You could put a round in the chamber without any magazine and it would operate as a firearm. And so it's not necessary to the use of any firearm, but yet we would naturally think that a magazine is a component of an arm and is therefore protected as an arm.
Yeah, there's a wide variety of such things. I mean,
Counsel, could you just, excuse me, I missed, rather than just say what is or what is not an arm, can you give me your definition of what we should consider an arm? We've been talking about is it necessary, is it essential, is it an attachment, is it accessory? What's the rule that we should look at and apply to this particular product if we think it's a silencer?
well, I think the definition of a firearm or an arm accessory would be anything that is used by the possessor to augment or help him use the arm. And of course, we all know from all kinds of extensive data that hearing problems are part and parcel of firearms.
Whether the silencer by itself is a bearable arm. Isn't the question before us, is a magazine by itself a bearable arm? Or is a silencer just considered in isolation a bearable arm? Or in order to reach the question of a bearable arm under the Second Amendment, do we need to consider the arm and all the attachments as a comprehensive unit, or is the unit to consider for a bearable arm simply the silencer by itself or the magazine by itself? Or do we consider only, in terms of a bearable arm, the silencer together with the rifle or the firearm and everything else? Do we consider the attachments in isolation, or do we consider them as part of a larger whole?
I would say that if the government is prosecuting someone for a possession of arms type of a criminal charge, based on, for example, possession of ammunition, think about bullets, think about a stand, think about stock extensions and things like this.
How could a silencer by itself be a bearable arm?
Well, it would be just like a stand
if
that
the firearm is
someone would.
perfectly operable without the silencer, how does the silencer by itself become a bearable arm? If something is operable without the silencer, then how does that become? How does the silencer become a bearable arm when it is not necessary in order to have the arm operable, the firearm operable?
Well, a silencer, in my mind, is no different than a sling or a holster. Of course, none of those are necessary, but those are things that
What
augment and
about
help
a
the user.
firing pin? Right, a firing pin is not necessary to the operation of an arm. You can create a firearm without a firing pin. So do you think that the government could outlaw firing pins because there's another way that you can create a firearm?
Again, I argue these are not arms, but if the government calls them arms, then there is the broad umbrella of protection of the Second Amendment, because all of these things that we're talking about, intent to protect the bearing of arms in America, and so clearly a silencer is something that helps users. We know that hearing problems are major issues, especially among veterans. And so silencers certainly would fall into the category of things that help firearm users.
Marvin, do you have anything? All right, thank you, sir, and let's hear from the government on this point and others.
Good morning, Your
All right,
Honors.
Mr. Samuels?
Thank you, sir. Good morning, Your Honors. Brian Samuels for the United States. May it please the court. Your Honors, I'd like to first turn to this sufficiency argument that the defendant raises, and I would submit to the court that overwhelming evidence supported the defendant's convictions for these possessions of 3 unregistered silencers. No matter what they were masquerading as when they were sold as solvent traps, these devices were silencers, and the jury appropriately found that. And looking at the sufficiency question, there were really only 2 elements that bring to bear on this. There's 4 elements altogether: that the defendant possessed the devices. There was no issue there. Second, that the device was a silencer under the law. And as we've just heard, the defendant argues that a solvent trap is not a silencer. But again, no matter what name was put on it, these were silencers. Under the plain language of the statute, and this is 921A25, a silencer is any device for silencing, muffling, or diminishing the report of a portable firearm, including any combination of parts designed or redesigned and intended for use in assembling or fabricating a firearm silencer or firearm muffler. There's then a third test that looks at just a unique part that is used solely for fabricating or assembling a silencer. The government did not proceed on that third test, but we did on the first 2. And the significance of that language is that it uses the language for, a device for silencing. And so
I think you've covered that all very ably in your brief. I'm kind of interested in the Second Amendment arguments, and we're still dealing with what Judge Richardson rightly posed as a threshold question here. And the question is, when does something become a bearable arm? And what, and by saying this is a bearable arm, do we open ourselves up to the fact that any attachment that is made to a firearm that makes it, and it could make it infinitely more dangerous, is all part of one bearable arm? And are we not opening ourselves up? I mean, the danger on the other side is that even minute adjustments to arms would not count. But what concerns me about saying that a silencer makes it a bearable arm, we are saying that any attachment, even to an operable firearm, even to something that shoots and does what we expect firearms to do, that any attachment, as far as I know, in the future, there will be any number, given the pace of technology, there will be any number of attachments which would be which would make a firearm infinitely more dangerous. In this case, it makes the firearm substantially more dangerous because the silencer is critical to evading detection by law enforcement, because you can't locate the direction or whatever from which the lethal shot was fired. And so I don't see the limiting principle here if we say that every attachment to an otherwise operable firearm thereby becomes bearable arms. You see what I'm saying? What does this hold for the future?
I do, Your Honor. And as I start to answer that, let me first acknowledge that I know this court has ruled in an unpublished opinion 1 year ago today, I believe, and I believe Judge Wilkinson, you were on that panel in the Salim case, that a silencer does not constitute a bearable arm. As the court knows, the government has taken the position in a supplemental brief that silencers do constitute bearable arms. And in taking that position, what we've looked at are that silencers are closely related to the exercise of the rights under the Second Amendment, that they are a firearm accessory that's useful to the exercise of that right, and that certainly I'll acknowledge, Judge Wilkinson, that there can be dangerous misuses of silencers, but there can also be benefits to those silencers. It can reduce the noise of a firearm, it can reduce recoil, and law enforcement and military.
Well, that's hardly what was at stake here. I mean, I realize that the armed services use those, the Marines use the silencers because they want to eliminate hearing difficulties that attend to the discharge of firearms. But I mean, as a practical matter, really, here we're not talking about people that are using silencers in order to mitigate hearing difficulties. We're talking about people that are using silencers to evade law enforcement. And
why do we think that? Is there record evidence that most firearms are used to evade law enforcement as opposed to avoid hearing loss or veterans who are involved in hunting? Is there any evidence in any record that suggests that most firearms are used illegally?
No, Your Honor, there's not. And we have not put forward the position that even most silencers are used illegally. What we've done is we've acknowledged that silencers can be misused, and that it can be the basis for some restrictions on a silencer in terms of registration.
You'd agree a handgun can be misused as well, right?
Yes, Your Honor,
Right.
of course.
Okay.
Our point in arguing that silencers fit within the confines of bearable arms protected by the Second Amendment are that silencers do have benefits that demonstrate that they facilitate the right to keep and bear arms.
So that's the test you would have us apply, whether we're talking about here silencers or magazines or grips or bipod stands or recoil pads or any number of products that can be used with firearms, is whether it facilitate, I think your word was whether it facilitates the...
Yes, Your Honor. Yes, Judge Quattlebaum. Sort of a bundle there, but closely related to the exercise of the right, useful to the exercise of that right, and a situation where the benefits of it would outweigh any dangerous use. We'd acknowledge that silencers are not essential.
What's the last part of your test? The benefits outweigh the dangerous uses?
Where they demonstrate that they facilitate the right to keep and bear arms, where silencers do have a benefit to them.
Yeah, I understood that part.
Yes, sir.
I thought you continued and had us do a balancing of the benefits versus the potentially dangerous uses. Are you suggesting we do that?
I'm not, Your Honor. All I'm suggesting is that when determining that silencers fit under the Second Amendment, as part of our calculus...
What are you asking us to do? To jump into a calculation of cost versus benefits? That seems an odd exercise for a court to be undertaking. And are you asking us to rule? I think we're being asked to rule a federal statute. I know you for us sustaining the federal statute, I suppose, but I'm just a little bit reluctant to, I wonder why these kinds of things just can't be determined democratically, as this one was by the Congress of the United States. And why the calculus and the balance between the benefits and the burdens of attachments to firearms, why the utility of that needs to be determined by a court as opposed to the Congress of the United States, as they've done in this particular instance with the statute in 5861D. But why isn't this a democratic issue rather than us sitting up here with limited knowledge of of what the benefits of the attachment might be and what the detriment might be? Where in the world does Congress's judgment fit in? It would seem to me that Congress's judgment should be well nigh conclusive in something that where the alternative is some kind of cost-benefit analysis from limited perspective and knowledge from the bench.
Well, Your Honor, let me be clear, and I don't know that I finished answering Judge Quattlebaum's question, but if I strayed into cost-benefit, I did not mean to. My argument was that the benefits of silencers demonstrate that they are closely associated with the right under the Second Amendment. So just looking at their benefits and utility.
And you do agree that if it is an arm, the question of whether it is a dangerous and unusual one, right, which has an aspect of its, potential dangers, is a potential argument that can be made. The government can regulate certain dangerous and unusual arms, but that's downstream of the question that we're talking about right now.
It is, Your Honor, and I'm not arguing that it's a dangerous and unusual arm. We're just arguing as to whether or not silencers fit within the text of the Second Amendment and they fit in the coverage there. To answer your question, Judge Wilkinson, certainly Congress can weigh in on the legality of possessing these devices without going through the proper registration and taxing requirements. That's what Congress has done in 5861 with certain firearms.
And this may be this is a claim about registration.
Yes, sir.
But if it's not an arm, it could be banned. So someone could, it may seem, in this particular case, you could argue as kind of maybe innocuous or more innocuous than other situations, but the consequence of saying it's not a arm, if we were to do so, would mean that this particular product, and maybe, depending on our definition, others can not just be registered, but could be banned. Correct?
I think that's correct, Your Honor. Our argument proceeds from the assumption that it is an arm, and then what are the restrictions, and are they reasonable?
And following up on that, Judge Richardson points out that the law that downstream would allow for the analysis of whether it's unreasonable or dangerous. Isn't the way Bruin reads, that's kind of an either or, depending on whether it's commonly used for lawful purposes? In other words, if you have these products that may increase the danger, let's say, if they're commonly used for lawful purposes, aren't they definitionally not unreasonably dangerous?
Well, yes, Your Honor. I think that's all a part of the first step in the analysis of Bruin, and then once we get past that step, then we get to the...
in the Fourth Circuit, yes.
Yes. Then we get to the restrictions themselves and whether or not those restrictions are an unreasonable burden. And looking at the restrictions that we have in this case, the restrictions are shall issue, so it's a presumption of constitutionality based on this court's rulings in the Maryland shall issue case that was done last year, based on the registration and the taxing requirements. And then even if we get past that to the second step of Bruin, and we do look at whether or not there are historical analogs to these type of restrictions, and as we've set forth in our brief, there are certain historical analogs that go toward the registration and record keeping for firearms. Which ones
did I recall you identifying, if I'm correct, the the 1600 registration of all goods that were to come into the colony of Virginia, is that right?
We did, Your Honor.
Did you identify any founding era restrictions beyond that?
Your Honor, I think we identified a restriction from the 17th century in Connecticut that banned selling firearms outside of the colony. So I believe that was another one that we identified. And then also a 1652 New York law that outlawed the illegal trading of guns and powder. So there were a number of restrictions. Of course, none of these are dealing with silencers, which weren't in play or an invention back then, but they were analogous type of restrictions to what we have here.
Why isn't the historical tradition one of many instances a complete ban? Because shortly, this is your prior brief, and I realize that the government has changed its position here, and you have every right to do that.
Yes, sir.
I don't question that, because it happens with some frequency, and it's a perfectly fine thing to do. But we, of course, still have the ability to find some merit, plausible merit in the prior position.
I certainly understand, Your Honor.
And so we're all trying to think about whether this is comfortably within the historical tradition, and I'm just saying, I'm wondering why the historical tradition couldn't be defined as, in terms of the state bans of silencers that followed rather closely upon their introduction. And your prior brief pointed out that states like Maine and New Jersey and others were pretty quick after the introduction of silencers to impose total bans. Now, why could we not frame the historical tradition in those terms? Because when we get into what's a modest burden and what isn't a modest burden, once again, is this, as in the previous question, injecting courts into a policy debate about what's modest and what is immodest. I'm inclined to agree with you that this is a modest burden, but I'm just a little nervous about whether we should be have all these judicial declarations of modesty when we can look to this same historical tradition. We all agree that Bruner requires us to look at the historical tradition, but the historical tradition has been one, it seems to me, of a complete ban.
Well, that's true, Your Honor. There's history, I guess, and there's history. We're looking at the history that goes back to the founding.
Why is your history better than this other history?
Because we're looking at the history that was in place at the time that the Second Amendment was enacted, which is why we're going back to that, Your Honor.
Has any court ever looked at the history from the 20th century to identify the meaning of the Second Amendment? I mean, has any court done that? Has the Supreme Court ever suggested that the 20th century history is what controls the meaning of the Second Amendment?
In this context, Your Honor, I'm not aware of that. Not to say that that's not been the case, but I'm not aware of it here. If I can make this...
Well, all I can say is that the only history we have is what happened after the introduction of silencers. I don't know that it's a very relevant history to take events that happened before silencers, and it seems to me, why isn't the most relevant history the response of the states after the introduction of silencers?
And I think one answer to that, Your Honor, is because what we're looking for is not necessarily a historical twin. We're not going to find that here because we didn't have silencers back then. But if we're looking at historical analogs, we can look back and we can see restrictions that are similar. But if I could just say, and maybe make this a little bit clearer and easier on my part, because this is a shall issue regime, this should enjoy a presumption of constitutionality. There's been no determination that there's any abusive ends associated with these regulations.
I understand that point, and I appreciate you making it. I'm sorry to do this, but we're getting near the end of your time.
Yes, sir.
I want to go back to the trial.
Yes, sir.
And have you respond to the exclusion of Mr. Speed's comment on the recording that if you, or something to the fact that you're a felon once you drill the hole.
Yes, Your Honor.
If you could address, what's the government's position on that?
Your Honor, the government's position is that the district court did not abuse its discretion in excluding that one line from the transcript. And the reason that was excluded is because that line went to Mr. Speed's mistaken belief that a silencer had to be operable to fit under the legal definition of a silencer, and it had to be registered. And those are not relevant considerations because a silencer does not have to be operable. The knowledge element goes to the defendant understanding the features of the device that bring it within the law.
So it's more in the line, not in the Ray Heath, but in the Staples type of situation?
That's exactly right, Your Honor. The defendant was certainly free to argue, and he did, that he bought these as solvent traps, that he thought they were solvent traps, that he intended to use them as solvent traps, and he believed he had these features. It was
Is
when
there
the
an argument that the statement, if admitted, I guess this, I mean, one could look at that statement as actually helpful to the government. It seems to me as evidence that the defendant, knew the purpose, and this showed a way to evade, the regulations.
I see my time has expired. Judge Wilkinson, may I answer your question?
Absolutely.
Thank you. Judge, I do think there's an inculpatory aspect to that statement where the defendant acknowledges that he knows that silencers have to be registered. The defendant was just mistaken in thinking that a silencer had to be operable to fit within the legal definition. It does not. The plain language of the statute indicates that, supporting case law indicates that. The defendant just had to know the features of them, and the evidence in this case was overwhelming that he certainly did. I see my time has expired unless the court has any other questions.
Thank you.
Judge Richardson, do you have?
Thank you so very much.
Judge Quattlebaum, do you have any further questions?
Thank you, I'm good.
All right, we thank you very much, and
Thank
we'd
you, sir.
like to hear from Mr. Roots in rebuttal.
Yes, thank you, Your Honors. I agree with much of what my opposing counsel said regarding the Second Amendment. However, they're also making the argument that this registration scheme somehow complies with the Second Amendment. Have to take issue with that. Under the Bruin decision talked about ubiquity of use, and that Stephen Holbrook Law Review article that we cited in our first brief, I believe that Stephen Holbrook Law Review article said that there are 1 million lawfully registered silencers currently owned by the American people right now in the United States. So this is ubiquitous use. These are items and accessories that people use with firearms.
Counsel?
There might be
I don't know if the technology is working. If you could, please, the government talked about the presumption of constitutionality for shall issue type regulations. I'm not seeing much that you've done to rebut that presumption. What's your position about how that presumption of constitutionality has been rebutted in this case?
Well, the Bruin decision talked about the Second Amendment is a right just as powerful as the First Amendment, and it talked regulation that somehow interferes with the rights of the normal ubiquitous use that Americans use. So Bruin and Heller certainly never held that all prior written gun control laws ever written by Congress are presumed constitutional or are constitutional under the Second Amendment. Rather, if you really look at the discussion in Bruin, they talked about how it really is an analysis of what is the American people's normal use. And again, over 1 million Americans own lofted this evidentiary thing because there was just, although the counselor said there was overwhelming evidence, that simply is not true. In fact, this required a retrial. First trial ended with a hung jury. Talked about one line being excluded from the transcript. The line where Mr. Speed expressed his innocence, the line where he said, well, I would never convert these into silencers because that would make anyone who did so would be a felon if they did so without properly registering. This goes to the knowledge of the device, the knowledge that Mr. Speed had, the totality of awareness that Mr. Speed had of these drip containers. The judge wrongly excluded the evidence that his knowledge of the devices was an innocent state of mind and that he had no intention of ever converting these into silencers. The only thing was this preposterous discussion of a future civil war or something that might be where all bets are off or something like that. So it doesn't even satisfy the plain language of the statute, which is, quote, any combination of parts intended for. It doesn't even meet that standard. So Mr. Speed is just plainly innocent, and he's been wrongly convicted of these charges.
All right, we thank you, Mr. Roots, and we appreciate very much your argument, and we'll come down and we'll take a brief recess and then come down and greet counsel.
This honorable court.
Okay, I thank you so much, Your Honor.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, please be seated. All right, it's United States v. Lawrence and Mr. Bryant.
Thank you. Good morning, Your Honors. May it please the court, my name is Patrick Bryant, representing Derrickson Lawrence in this appeal. As time permits, I'd like to discuss each of the issues that we've presented in our briefs, but I'd like to first discuss our severance argument. The district judge erred in joining for trial count 11 with the other 10 counts. Mr. Lawrence was initially indicted in July of 2023 on counts related to the payroll fraud. Months later, the government superseded to add count 11 related to the PPP fraud. There's no direct relationship between those alleged schemes. Rule 8A provides that joinder is appropriate when the counts arise from a common scheme or plan, the same act or transaction, or have a same or similar character. That's not the case here. The only commonality of the alleged...
But isn't severance a matter that's sort of ultimately as much as anything in the discretion of the district court, which is familiar with all the different claims and the nature of the different claims?
Well, this court's review is de novo of the legal question of whether these...
No, it's not. This court's review is for abuse of discretion as to whether severance was warranted or whether it was not.
I believe, Your Honor, respectfully, that I recall from the Hawkins case from this court that the legal question of the application of the rule 8A, whether these schemes fit within the language of the rule, I believe is a legal issue. And the district court certainly has some power and is more familiar with the case. I mean, although at this stage it's only looking at the indictment, and so it doesn't have any familiarity beyond the mere allegations.
Just to follow up, I mean, Judge Wilkinson, I think, is right in terms of the severance question. Whether it severs joined cases is, I think, plainly abuse of discretion. Your argument, I think, relates to the joinder in the first place, which may be a legal question.
Yes, I guess that's correct. And to clarify, 8A is the legal question about whether joinder is appropriate. If joinder is appropriate, then Rule 14 discusses whether it still should be severed due to prejudice. I think that probably is a discretionary decision. But either way, under either analysis, we think the district court erred. The only commonality of these schemes is Mr. Lawrence, and that's too high a level of generality. Simply any fraud allegedly committed by the same defendant is not necessarily joinable in the same trial.
But you have an argument, but that's not your argument, right? Like, nobody thinks the only thing that relates between these two things is the person, right? I mean, like, grapple a little bit with where the similarities are. It's not just the person, right? So he commits a massive fraud against a company that causes his company to effectively go defunct. He then tries to fill that gap with the PPP. They're all involving the same entity. They would involve the same witnesses or many of the same witnesses that would testify. I mean, that might not be enough, but when you make the argument and say the only thing that connects them is one person, like, you just fail to grapple with the hard question that might be here. I'm not saying it's not a hard question, but you don't help me, at least, without discussing and thinking about the sort of temporal connection, the entity connection, and the government's argument that they were in fact connected because the PPP fraud follows after he's lost everybody's money, and that he does them in very similar ways, right? He wires the money from both frauds through the same account. He's using them in the same illicit manner, I mean, to say it's just one person, like, I think sort of misses the point.
Well, I understand that contention, but here's why I disagree with that. That the the government's own charging document separates these in time. That the original fraud, the government says, ended as no later than December of 2019. The PPP fraud didn't arise until April or May of 2020, and so the temporal connection is really only just one after the other. It's not that they overlap in time.
I understand that, but that is a temporal connection, right?
Well, it's more distinct than a temporal connection. In Hawkins, there were only 17 days apart, and this court said that was distinct
A
enough.
lot of this problem is handled through instructions, and the district court had a very explicit instruction that each count was to be considered separately. And I think we generally follow the rule that the jurors take district court instructions seriously. And to me, this quintessentially boils down to a question of trial management, where the district court has a valued perspective. And as Judge Richardson pointed out, there's just a lot of reasons to avoid the cost of severance. And the cost of severance are you're going to have these witnesses that are going to be dragged in for a second time, and you're going to have to impanel another jury and all of the rest, and it's going to be an additional drain on judicial resources. And that might be fine in some cases, but not in a situation where the same company, Market View, was used to conceal what he was doing with his employees' funds. And it was the same company, it was the same methods employed, it was the same intermediary bank account that was concealing things. And the nature of the fraud was the same. This gentleman was taking funds from his employees, most of whom were restaurant workers and were living a lot closer to the line than the defendant here. And he was taking their funds, and he was misrepresenting the kind of investments that were going to be made with those funds. And he invested in options trading, which we all know has the highest element of risk. At the same time, he was telling his employees that they were all in safe money market funds, and then he lied to them about the fact that he was taking their money and investing it in an entirely more reckless vehicle than what he represented to people whom I say again, many of whom are living close to the line. And he was doing this with the very same strategy and company and means that was present in all of the counts. It was present throughout in those counts. And I think that there's a large discretionary element involved with this. And I honestly, I thought it was a good trial. I thought it was a well-run trial. And the jury smoked it all out. And it said that it wasn't some kind of bad business judgment or breach of contract or whether. No, it was out and out fraud, and the jury smoked it out. And that was true for one count, and it was true for all of them, including the PPP application in count 10 or whatever it was. But I think there's a great deal more commonality than you're admitting. And I think Judge Richardson pressed you on that point, and I didn't see that it was a very, I think it's a difficult one.
Well, I understand that position, but I think that the one distinction is that there's a distinct method, a problem with the method, that one is money that he has a right to that he might be misusing versus money that he doesn't have a right to that he's obtaining by false pretenses from the government. And so I think that's a distinction. And even if and Hawkins was a case where even though there was a curative instruction and even though there was overlap in the evidence, this court still held that there was misjoinder. I think that the evidence does not overlap as much as the government says. The PPP fraud would have been very discreet, and to the extent that it's easy to parse these apart, and if it's so easy for the jury to differentiate between the alleged schemes, that makes it easier to have a separate trial.
In this particular issue, you overturn a district court on a question of joinder and severance of counts, and you have a case like this, and then you have 15, 20, 30 cases following in its wake. That's what we let ourselves in for.
Well,
at any rate.
Well, I don't think that that's been the case after Hawkins, and I understand the court's position on that. With the time I have remaining as I'm winding down here, I'd like to move to our sentence argument about the application for the enhancement for the use of sophisticated means. The commentary to the guideline says that enhancement should only apply when the offense involves especially complex or especially intricate means, which presupposes that there are going to be some offenses that could be characterized as complex or intricate that still do not qualify for the enhancement. It must be more than the complexities inherent in the fraud itself. And here, all that we...
That's in the commentary?
Yes.
Is sophisticated means ambiguous?
We haven't made an argument along those lines, or that there should not be deference to the commentary. We think the commentary helps us because it clarifies that it has to be something over and above. So I think I understand where you're going with that.
My point there is, I think the law is after Kaiser at least we don't go to the commentary unless the guidelines are ambiguous and sophisticated. Maybe it meets the commentary. I think there's I'm not sure there's a clear error that it's not, but I'm not sure it's just, not in the first instance, a sophisticated means in terms of the way you could look at the array of criminal activity.
Well, I understand. So even if you just take the generic term sophisticated and you ask the question, was this a sophisticated offense, I still don't think it would apply, because all we're talking about here is dumping money into one account and then moving it into another account.
What's our standard of review on this issue?
I think it would be clear error because it's a factual finding. We're not getting into the legal terminology, but the district court's findings at 1245 and 1246 of the appendix are very minimal and really says that anything beyond just taking money out of the cash register would be considered sophisticated. And I note that...
Is that fair? I don't know that he said anything beyond that is sophisticated. I think he was saying, here's something that's not, here's something that is. I don't think that's entirely fair.
Well, that's all we have to go on is what's in the transcript. And he says, this was sophisticated, and unsophisticated fraud is taking money out of the cash register. And I think that's just, that the only logical inference is that he thinks that, well, at a minimum, there's a huge gulf, and somewhere there's a line.
I would note it's almost in the nature of an aside. But I would note that your client had an MBA in international finance.
That's correct.
He was certainly capable of employing very sophisticated means if that's what he set out to do. And when you look at that chart, That's, just from a layman's perspective, it looks pretty sophisticated and complicated to me.
Well, I understand, but the Adepoju case from this court specifically rejected the contention. The district court in that case said, well, this is something that an ordinary person couldn't do. You needed some expertise to do this. And this court said that's not the standard. It has to be something that is over and above, more complex
Well, this
than
is
the
more complex. I mean, the district court, as I recall, made a statement, and I'm quoting it. He said, this whole scheme is, quote, impossible to understand. I mean, that's from, he's looking at this chart. He's having the same reaction I am. The district court is saying, this is impossible to understand without a whole lot of work. And I'm saying to myself, hey, that's where I am too. And this was, it really is quite complex. The trail that this money was blazing in through these different accounts and these different subterfuges.
If I can respond to that briefly.
Yeah, absolutely.
I think it was still traceable. It doesn't make it especially complex, especially because if you look at the comparator language that's in the guideline about phony entities, phony businesses, and again, the Adepoju case had identity theft and forged instruments.
Help me understand. The Adepoju case obviously relies on Stinson and the suggestion that the commentary is binding. That is no longer the law in the Fourth Circuit. And so I guess I'm having a little hard time understanding how I do anything with Adepoju given that we no longer follow Stinson.
Well,
I mean, you agree with the premise, right?
Yes,
I mean,
that's
so
fair enough.
the reasoning that's given here is to quote the commentary and then apply the commentary. Well, we sort of now know that's not what we do. So why? I mean, I understand you want to go to it because you like the result, but how am I supposed to apply a case that's now based on reasoning that's been squarely rejected by this court?
well, I think my response to that would just be that even if you just rely on the guideline itself, we don't consider this sophisticated because there's nothing beyond an ordinary fraud offense. And unless there are questions now.
I would say that, there's sort of a sad dimension to this case because, and it relates to the sophisticated means point, but the people that are being defrauded, again, they're restaurant workers, and many of them don't have the advantage of the education that your client does, and they certainly don't have degrees in international finances. That may not be true of all, but some everyday hardworking, honest folks who are being taken advantage of in a very basic way by somebody who had all the advantage of an advanced degree, and he's using his education to deprive hardworking people of their hard-earned retirement, and it's a sad thing when people with means and education prey upon people with less advantages. Maybe that's not true in the case of all the employees, but it's bound to be true of some of it. And I think that kind of predation is a very, very sad thing. And I think the jury saw it. It's not how I see it, it's where the jury saw it. But I think this is what the jury saw, and I think they darn well didn't like it.
Well, I understand the court's concern, and our position is that there are still grounds to reverse the conviction and vacate the sentence. Thank you.
Good morning, Anthony Mosey for the United States. May it please the court. Your Honor, defendant appellate Derrickson Lawrence asked this court to overturn his conviction after a jury trial for stealing the salaries of restaurant employees that were entrusted to him in his role as the CEO and the sole owner of Market View. To follow my colleague's organizational structure, I'd like to start with the severance issue and then briefly touch upon both the sufficiency of the evidence claim and conclude on the sophisticated
When you say
means.
severance, are you starting with joinder?
Yes, Your Honor. There are sort of two issues here that Your Honor, Judge Quattlebaum identified. The first is Rule 8 misjoinder. That's a de novo review. Then I want to touch briefly on harmlessness or any prejudice the defense talked about, and finally conclude on the Rule 14 severance, which is an abuse of discretion review. As to the misjoinder argument, Your Honors, there was a common scheme or plan, and at the very least, these were of a same or similar character. The analogy here is that the defendant had complete control over his company, Market View, and he had access to two separate pots of money with which he promised to do very specific things. So for the employee salaries, he said, I'm going to keep these things safe, and I'm only going to make specific kinds of investments. What he did in actuality, and what the jury heard at trial, was that he funneled those through an intermediary account, this Wells Fargo 7523, and then transferred them to make options trades in his own personal brokerage account, and then used that money when he had some success, which was limited, to sort of fund his own personal expenses.
But the challenge with this is that, like, the argument at that level of generality suggests that any fraud claims can be brought, right? But what we've got here, as your colleague pointed out, is fraud that's happening on two different ends, right? The PPP fraud is the fraud in the acquisition of the money. It didn't matter if he then actually gave it to employees, right? Because he was fraudulent in getting it. So it doesn't matter how he used that money. All that matters was the fraud on the front end, where the employee fraud was on the back end, right? In the misuse of that money. And so if we say, I mean, it doesn't really feel like it's the same plan or scheme, right? One is fraud on the front and the other's fraud on the back. If we can just let in any fraud, then Rule 8 doesn't do much, does it?
Well, respectfully, Your Honor, what he did with the money that he received for the Paycheck Protection Program goes to his intent when he was making that application.
Might be evidence, but it's not the actual, offense, right? The offense was in the application. His fraud was complete when the application was made, right?
That's correct, Your Honor.
So it doesn't matter the point is, it doesn't matter what he does with the money. That's not true of the other fraud, right? So the fraud only exists once he misuses the money, right, to engage in trades that were improper.
Fair, Your Honor. I do think it's worthwhile to highlight that the government's indictment charges only these statements and wire frauds that he was making in 2018 to 2019, and at that point he is taking the money. Our case.
Yeah, but to follow up on that, the representations may have been earlier in terms of the fraud with the employees, but the damages and conduct, which are all part of that, that's way more intertwined with the post-acquisition of money is way more central to the first fraud than the second.
That's fair, Your Honor. There were continuing misrepresentations to the employees. So, for example, he maintained a website where they could access what was purportedly in all their individual accounts. And there's
What if he
evidence in the
goes
record.
and robs a bank and sticks the money in the same accounts and goes through the same accounts to the other and end up being invested in day trading or whatever he's doing? I mean, would that be the same? We're using the same accounts, same guy, starting in the same business account. You're going to trace all that stuff. I mean, why wouldn't that be joinable if under your thinking?
I apologize, Your Honor. The way that I conceive of the case is if you were robbing a bank and then you decided to rob a 7-Eleven, there are obviously different sources of the money.
No,
that's
I'm
made
talking
available
about
to
in
you.
this case, he robs a bank, but sticks the money in the same, I mean, part of your argument is he's using the same accounts going through the same financial process with the proceeds of his crime. And as I read your brief, that was one of the things that you used to say similar conduct or similar scheme. And you could do that if you got the money by robbing the bank, as opposed to some financial fraud.
That's correct, Your Honor. I do think the government's stronger argument here is that there are a similar character as to these two separate thefts, both the paycheck protection fraud and the stolen money from the salaries from the Golden Corral employees. I think certainly if this court were to find that that was sufficient, it doesn't need to reach the question of whether or not these were the same scheme or plan.
Could you, I'm sorry, Judge Willis, were you about to? I would like to hear your, I think this is a, interesting question, this joinder question. I appreciate your arguments, as I appreciate your colleagues. I am interested in your harmlessness. If we were to assume misjoinder, and let me just say, I think on the abuse of discretion of severance, I think that's, I think that's pretty, not an abuse of discretion. But how do you say it's harmless if it was a misjoinder?
A couple of reasons, Your Honor. So the indicia here under this court standard in Mackins includes whether or not the evidence of guilt was overwhelming and the concomitant effect of any improperly admitted evidence. Here, Your Honor, there was overwhelming evidence of both of these separate schemes. Obviously, the stealing of the employees' salaries was a little bit more sophisticated and required more understanding. But the financial analyst who testified, I think, made it fairly clear, and the jury saw that this wasn't a case where someone was investing. He was taking the money. Investing implies that the principals, in some instances, would have been transferred to the investment account, and that principal would have been transferred back. The evidence at trial, in fact, is that there was only one transfer out of the brokerage account during the 2-year time period for about $10,000. In contrast, there was about $200,000 that was transferred to that brokerage account.
Do you think if they had been non-joindered, that the PPP trial could have included what I'll call the employee fraud as 404B evidence?
Yes, Your Honor, and there would have been substantial overlap in the witnesses the government would have called. So first, Mr. Ellsworth, who was Market View's only employee other than the defendant, would have been called to testify.
That's a different issue. Maybe I cut you off too soon, but I don't think he's asking about same witnesses. I think he's
Right,
talking
404B, is it a prior bad act that would be admissible in a second trial? So imagine we've got 2 trials. We've convicted on the employee fraud, and we now have the PPP fraud. And the government goes to the court and says, we want to introduce evidence of the employee fraud as 404B evidence, right? Evidence that goes to the motive and means of the defendant. Would it be admissible?
Yes, Your Honor.
And tell me why, which I don't think has anything to do with the same witnesses.
So I apologize, I was jumping ahead, Your Honor, but yes, the witnesses sort of reflect the 404B evidence. So he was without any source of income after Market View collapsed in 2019 because Golden Corral no longer was transferring this $80,000 or so every 2 weeks to him. In fact, there was evidence at trial that he reached out again in 2020 to the CFO trying to sort of gin up more business. So this goes to his intent, the reason why he was doing the paycheck protection fraud. He literally had no money at that point. Also, the fact that he was in debt to them, as he knew, by several hundred thousands of dollars, again, go to why he felt the need to sort of misrepresent this and get this money.
Let me ask you one further question here with respect. Even if there was a misjoinder or an abuse, and let's say that for misjoinder we look at it de novo or what have you, but the fact that the standard of review is de novo doesn't mean that misjoinder is a structural error. That it would still be subject to a harmless error analysis, and there's no other way to go on a harmless error analysis but to look at the evidence of guilt with regard to the particular count that the defendant claiming here was the subject of a misjoinder. In other words, the fact that there's a de novo standard of review does not mean that there's a structural error in the system and that it's immune from any kind of harmless error analysis. And you point out that the evidence on this count was pretty doggone well overwhelming. And what I'd like you to do, because I think it does pertain to harmless error analysis, if indeed there was an error at all, why don't you just talk briefly about just how much evidence was introduced on this point?
Yes, Your Honor, and I think this is going to the sufficiency argument a bit as well, talking about the overwhelming evidence of the defendant's intent to defraud. So first, as I talked about...
I say the Supreme Court has been very reluctant to say that this category of error and this category of error is a structural error and immune from harmless error analysis, because the whole idea that Justice Rehnquist posed that you're entitled to a fair trial, but you're not entitled to a perfect one. And I'm sorry because I cut you off, but I want you to talk about just how overwhelming the evidence was with respect to this particular count.
With respect to the paycheck fraud, Your Honor?
Yes.
Yes, Your Honor. So the evidence at trial showed that the defendant had taken hundreds of thousands of dollars.
That's count 10, is it not?
Counts 1 through 10, I believe, Your Honor. Count 11 is the paycheck protection fraud. That he had taken hundreds of thousands of dollars out. He was aware that that account had insufficient funds to cover transactions as early as January of 2019. There was an email where he actually acknowledged lending about $30,000 out of that pooled account to his spouse and saying that he was in a hole at that time period. Again, the cardholder agreement never allowed him to make loans to other people based on that information. In addition, Your Honor, although the defense focuses quite a bit on the language in the cardholder agreement, that actual language foreclosed the sort of risky options trading that the defendant was doing. That was the expert that the United States called at trial. The language specifies that he had to invest the money in money market funds that had been secured by U.S. Treasury obligations. And as the expert testified, in the history of our country, there has never been a negative return for those sorts of investments. They've never lost funds. In contrast, the defendant was investing in options, and even if he didn't have an MBA, and even if he wasn't a sophisticated individual, he should have known that these...
Your colleague, if I'm remembering this correctly, I may have the wrong case, there was a mistrial though, right?
No, Your Honor.
There was no mistrial here.
No mistrial in this
case. Okay.
The jury came back rather quickly, actually, Your Honor.
An additional factor that makes this a particularly unsavory business, and that is that on the few instances where his options trading resulted in some gains, he never put those back into the employees' accounts. He kept them for himself, even after the options trading, on the rare occasions where the options trading resulted in some profit. What did he do with them? He kept it for himself. He never returned it to the accounts where the people, where it rightfully belonged. And I come back to the harmlessness point and not holding this to be structural error, if indeed there was error. But in addition to the overwhelmingness of the evidence, we always look to the way in which the case was submitted. And as I recall, and I don't have the language in front of me, but as I recall, the district court took pains to say that these are separate counts and they should be considered separately. And we always, we think that juries take district court instructions seriously. And when you look at the overwhelming nature of the evidence that's introduced on this count, and you look at the district court's instructions and everything, that should be enough, it seems to me, to find harmless error, if indeed there was error. And I think I've made my point on this, that this is not a structural situation. It is to start creating structural errors. That's a path of mischief.
If I can respond to the two parts of your question, Judge Wilkinson. The first is about what he did with the funds when he did actually get a return. And these were exhibits that we put in front of the jury through the financial expert. It's Government's 803, which is Joint Appendix 7438, and 802, which is Joint Appendix 7422. And that showed the jury that the transfer of the funds out, transfer of a couple $1,000s or so when he did make profits and didn't lose his shirt, and then what he did with it, including paying for his spouse's expenses, Home Depot, and his son's private education. Your second point, Your Honor, going to the issue of harmlessness, it's also telling that the defense only highlights two issues, really, of prejudice that their client suffered as a result of the joinder. And those two issues, frankly, were first that he was forced to concede, really, the paycheck protection fraud. But the record reveals that the defense was using that offensively in an effort to get sort of a compromise verdict. In the closing argument, the defense called it a helpful comparison to look at the paycheck protection fraud, saying that's fraud. But what he did with respect to the salaries was not fraud. That's JA 963. Second, the defense argues that Mr. Lawrence faced risks if he chose to testify. That if he were to testify perhaps only on the paycheck protection fraud, the government would be able to cross-examine him on the salary fraud. The trial court was very careful, and immediately after it made its oral ruling about denying the motion for severance, the trial court said that he expected you all to be prepared to address the issue of limiting cross-examination when it comes up at trial. And I'm not going to allow them, meaning me, the government, to go through everything this fellow ever did in life on cross-examination on the fraud case, on the restaurant case. There was an invitation for the district court to go beyond just the limiting instruction that you highlighted, Judge Wilkinson, but also to limit the government in its cross-examination. That time came at trial, and the defense never re-raised that issue. And yet here is asking this court to sort of look into this black box about what limitations could have been done, what sort of additional efforts the trial court could have taken to limit that prejudice, and just say instead, no, even without that information, my client should get a new trial. And so for that reason, I don't believe that it would be appropriate here to, even if this court were to find that misjoinder occurred, I do think the harmlessness applies in this case, and I don't believe that there was harm caused. Just to conclude very briefly on the sophisticated means question, Your Honors, unless you have any other further questions, we highlighted the chart government's, or rather Defense Exhibit 30 that was used during the cross-examination of the financial expert. I think that was used by the defense in an effort to just suggest that no one could understand what was going on here. Respectfully, this is not a case about just one or two accounts. It was a case about many accounts. Among other things, the defendant had access to his deceased mother's estate. He was taking cash out of that to infuse it into the pooled settlement account to sort of hide the fact that money was going through. And then the nature of the cardholder agreement, I think, is the sort of most distinguishing fact. When the FBI knocks on Mr. Lawrence's door in 2021, we have, at that point, the financial records, but he uses his sophisticated understanding and hides behind this financial language in the cardholder agreement. And to the average sort of juror, I think that would be something that was indecipherable. And that's why the government had to, and I think appropriately, called an expert to talk about that language. That alone brings this case out of sort of the realm of a a regular wire fraud case. The trial court wasn't suggesting that everything that is not simply a robbery of a convenience store is sophisticated. His reasoning, although it was somewhat brief, talked at length about the different things that he had done. And again, unless your honors have any further questions, we'd rely on our brief and ask you to affirm the defendant's conviction.
Okay. Do you have any further questions?
Thank you.
All right, thank you. You have, Mr. Bryant, you have some rebuttal time, sir. Could I ask you, because we didn't really touch on that, but your basic defense at the trial seemed to be that all this case was really about was a sort of civil breach of contract claim, and that Mr. Lawrence did not engage in any sort of fraud, but what he just, this is really at bottom just a case of poor business judgment, that he was out to make the best deal that he could in some way for the employees, and the investments just didn't turn out to be profitable. How could you make that case in light of this record?
Well, I understand the court's concern. We've argued that a mere breach of contract is not necessarily a crime, and
Well, we would all agree with that.
right, and so I think that's true even if you think that there is a risk that that might come up. So take, for example, if I take out a business loan to open a restaurant is a risky industry, and a lot of restaurants fail. And so imagine that I've operated a restaurant for a decade, just like this business arrangement lasted for over a decade. And then the COVID pandemic hits, and all of a sudden the restaurant's failing. I can't pay my staff. I can't pay my vendors and suppliers and rent and taxes. So I get kind of desperate, and ultimately the business fails, and I'm not able to pay my bills. That's a breach of contract for which there are civil remedies, or maybe eventually bankruptcy, but it's not necessarily a crime, even if I know that possibility might arise. And the one quibble that I'd like to have with something that the government said, Mr. Lawrence did not promise that he would only invest the funds in treasury-backed money market accounts.
But what he told the employees, wasn't that a jury question?
I don't think so if, as a matter of law, there's not a misrepresentation. And the representation he made was that the funds would be available, and I will invest them in something that's short-term and liquid. So he couldn't invest, for example, in a CD.
I thought the explicit representation was made to the employees that their funds were going to be used in a risk-free U.S. Treasury-backed money market fund, which is about the safest kind of investment that one could ask for. And then instead of the safest kind of investment that one could want, what happened was it was put in the riskiest vehicle that one could possibly ask for, which is the kind of options trading that took place. And so you're talking about investments at the opposite ends of the risk spectrum, you see?
Well, I do see what you're saying, but the words risk-free were not in the representation. All he said was that it would be liquid and available. It's no different than a bank. And if there's a run on the bank hasn't committed fraud just because everyone comes to ask for their deposits at the same time. If the bank hasn't made some necessary representation, that's why we have deposit insurance. I would like, since my time is winding down, to turn back to our severance and joinder issue. We're obviously not arguing structural error. I want to be very clear about that. But I do believe that there was harm here because it affected the trial strategy to such a degree that Mr. Lawrence was put in a position where he effectively had to concede the PPP fraud count. And yes, he did try to use that offensively to draw the distinction, but he wouldn't have had to do that in a sole trial. If he was only on trial for the PPP fraud, he never would have conceded it. He only had to do that because it was joined with these other counts, and it created this risk that the jury would apply a propensity inference that because he committed one fraud, he necessarily committed the other.
Can you address the 404B point? Because
Right.
it seems like to me that if you were trying the PPP fraud, that you could put in maybe all of, but virtually all of the evidence that came in during the employee fraud.
Right, I was coming to that. I would have to think about it if we're sort of in this counterfactual,
Yeah,
and I'd have
but
to
that's
go
what
through
we
it.
gotta do.
I understand. I think that, I don't think I could deny that none of it would be relevant. I think that we certainly wouldn't have a week of evidence on that with days and days and tracing every bit of this. All that would really be necessary was something of an overview to explain why he didn't have the money at the time. And that's why I would point back to the Hawkins case. Hawkins had a carjacking and a felon in possession, and so obviously some of that, the fact that he used a firearm in the commission of the carjacking might have been relevant or might have been 404B.
But you haven't answered, I'm not sure that you've answered Judge Richardson's question, because I mean, how could it not be admissible if it goes so directly to notice, to motive and intention?
If I can continue here.
Sure.
I'm not denying that there might be some relevance and some overlap. I'm just saying that it wouldn't be presented the same way. We wouldn't have this
No, but it would come in, because it's, of all the exceptions to general character evidence under Rule 404B, I would say motive and intent is probably the most common. That's why I think that, to me at least, Judge Richardson's question was a highly relevant one.
I understand, and I'm not denying that there wouldn't be some overlap, but again, I think I would point to the Hawkins case, which said that even where there is some overlap and even where there is a limiting instruction, there still are cases where it's not fair to ask the jury to parse those out.
Just even on the harmlessness point, we've been over it, and I don't want to repeat it, but we do have the amount of evidence that is introduced with respect even to this count, and the jury instructions and the 404B issue down the road, and there's a lot to address.
Well, I understand, Your Honor, and just for the reasons we've stated in our brief, we disagree with that. And if I may, just one last point very quickly. I know the court is aware that Mr. Lawrence sought to represent himself in this case. The court denied that, but did give him permission to file a pro se brief. We certainly on his behalf asked the court to consider those arguments along with the ones that we've made, and thank the court for giving him that opportunity.
Well, I
Thank
see
you.
that you're court assigned.
From the
and,
Public Defender's Office.
I think you did a fine job, and we like to come down. We'll move and turn to the next case, but we want to come down and shake hands with you. But I always, Mr. Bryan, I always tell people, if you're mad at me, you don't have to shake my hand. right, we have Pendarvis v. Wilson and Mr. Luck.
Thank you, Your Honor. May it please the court. My name is Jason Luck. I'm here representing Trent Pendarvis in this appeal. We are asking the court to reverse the district court and allow Mr. Pendarvis to file his complaint, any of the complaints below, so that the case can proceed on its merits. Now, at its heart, this
How
is...
many thousands of pages is the third amended complaint going to be?
The third amended complaint is part of the record, Your Honor, and it's, I believe, a very reasonable amount compared to the first, though I would argue the first complaint is not completely unreasonable either, in light of a lot of other issues. And of course, I said this is a case about due process, but this appeal is a lot more about formalism and about litigation and how we practice law these days and how we plead these days. Because we all know that Rule 8 only requires us to submit a short and plain statement entitling us to relief.
So, counsel, the argument you're making, I think, is whether the district court should have permitted the amendment. Is that correct?
That's my favorite argument, Your Honor. There are other grounds for relief.
Well, let me, but on that issue, would that be, it wasn't, it wasn't refused because it was futile, so it would be an abuse of discretion standard on that issue? Do you agree with that?
It is, Your Honor.
Okay. Can I ask you something going, backwards, I guess, in terms of a preliminary issue? If we look at the operative complaint at the time of the ruling was the second amended complaint.
Correct.
This isn't briefed, so I apologize for bringing an issue that's not briefed, and you do with it what you can, but I know that's not something litigants like to hear, maybe. But based on the way that's briefed, do we have subject matter jurisdiction at all? In other words, does that second amended complaint, allege any Article 3 jurisdiction?
Well, Your Honor, this is partially brief, though, so this is good you mentioned this. One of the issues that I do describe in the briefs is that, yes, you have to look at these complaints within their greater context. And so the four corners of the complaint say this or that. Well, at least we have the benefit in this case. If that complaint had been filed in a vacuum as the first complaint,
right,
I would be in a very bad position right now. But it's not. It has the benefit of a record.
So you make sure I understand your point. It sounds like you're saying, second amended complaint on its own may have some, problems in terms of Article 3 jurisdiction, but we shouldn't look at it on its own. We should look at the original complaint and the first amended complaint.
Well, I don't necessarily think you should look at those complaints because they are, after all, a nullity, but there is evidence attached to them. It is part of the record. Those images, those bits of evidence contained within those complaints didn't just disappear after the complaint was amended. They still exist, and now it's part of the record.
Wait, just so I understand, your argument is, excuse me, is that the first complaint is a nullity, but the attachments to it are not a nullity?
Well,
I just want to make sure I understand your argument. That is an argument, but that's the one you're going with?
Well, Your Honor, it is, when I say it is a nullity, it's a nullity for the purposes of going forward. No one's going to have to answer it. But it does,
No, it's not just a nullity in that way. We've said it's actually a nullity. We can't consider it. We can't consider the complaint, but you want us to consider the attachments.
Traditionally and throughout consideration of motions to dismiss, 12b6 motions, matters outside of the pleadings have been considered.
When attached to the operative complaint.
Or referenced within, or integral to the arguments of the complaint. There are ways that frequently extra pleading materials do get considered by the court.
And tell me why in the second amended complaint, you reference, attach, or integrate any of the documents you think we should consider. Give me an example of an attachment that's a nullity that was revived by virtue of incorporation into the second amended complaint.
So you say example of attachments that would be, now, don't have the complaint in front of me right now, but again, I have to say we have to have a little leeway provided here because there is a record of this case that contains a lot more than just simply procedural decisions. And
So at least as you stand here, you have no example that you can give me.
from the complaint, no, I can't rattle it off by memory, but it is part of the record.
So
And
Can I maybe, let's assume, I appreciate your argument that we have that, and maybe it's referenced, maybe it's not, but it's there, and your argument sounds to be like we can look beyond the second amended complaint. We'll either agree or not. But let's assume you don't prevail on that, and there's no Article III jurisdiction as a result of your second amended complaint, okay? If that's the case, can we consider the district, the decision not to amend? Can we still consider the argument if we don't have jurisdiction? Do you have a position on that?
it's a fascinating argument, Your Honor, but it's
It's not
partially.
an argument, it's a question.
Sorry, Your Honor. It's a fascinating concept because, of course, it is something that's something I didn't have to consider earlier.
Right,
But
that's why
But thinking, just top of my head here, bear in mind that all of these, the matter of dismissing the case and amending the pleadings were all considered together. I mean, there is, in the end, if the complaint that seeks to replace the second amended complaint does, and again, we're just going to assume for a moment, for the sake of this argument,
understand.
second amendment complaint, no jurisdiction, the complaint that replaces it does.
Well, that would replace it if
Would.
you're permitted to amend.
Yes, Your Honor. If we are permitted to amend, in effect, the motion to dismiss the second amended complaint becomes moot. And we're not really discussing, we can discuss jurisdiction, but the issue of jurisdiction was mooted by the amendment that also seems to correct some of the issues that the magistrate judge had as well. So,
I suppose you can run afoul of Iqbal and Twombly by submitting a pleading that is just totally bare bones. You cited to me the requirements of Rule 8 and everything in their pre-Iqbal and Twombly state. This is one of those claims where it seems to me that the problem is on the opposite end, not that the complaint is too bare-boned, but that it's too voluminous. And the question is, when you have a complaint that is this voluminous, and here you are talking about, I don't know how many, there was something like, in the First Amendment, in the first complaint, there were 33 different defendants and 92 pages and 101 documents. And the amended complaint didn't really cure those deficiencies because there were 32 defendants and 44 pages and numerous pages of exhibits in the left. And that raises the question to me, what is the district court supposed to do? You seem to think that the district court's going to become sort of a quasi-advocate for your position, and that the district court has an obligation to fish through all of these voluminous documents, and I don't understand the district court's job. It's your job to make clear to the district court exactly what causes of action you have and against whom and why. And not only is the district court hit with a stupendous task, but the defendants have a hard time rummaging through all these documents and say, well, now which cause of action pertains to me and why and what are they pleading? And the question is, have you given the defendants any kind of fair notice at all? And so this kind of pleading seeks to shift your burden onto the court and onto the defendants. And they're supposed to make sense of something that is very, very hard to wade through. And so I don't understand why you had 2 bites at the apple, and the second bite refused or didn't cure the deficiencies that were notified and identified in the first. And this just presents a situation where the judicial process is being taken advantage of. And that's my concern here. You're not the only rodeo in town. There are a lot of other cases and everything else, and district courts and defendants should not be required to do your job for you. And how do you get around that?
Well, Your Honor, see, this is, one of the reasons that gosh, I've lost my train of thought there for a moment. The case itself, if you look within the complaints, the causes of action do name the individual defendants. And these complaints are long because these are complicated matters. Now, you talk about how many bites at the apple. This morning I was looking at these complaints and realizing what I was seeing there, and there was first an order to more definite statement. That was the order. It said no embedded exhibits, basically take out all the things that are in line within the complaint, some other issues. So the trial counsel did that. He took out what he thought were the exhibits out of the complaint. Apparently that wasn't what the judge wanted. The judge said, do it again, do it this way, and he overcorrected on the second amended complaint. That's what it looks like to me. Now it says it's taking advantage of the system.
Well, the district court certainly didn't feel that they were corrected.
That is correct, Your Honor, but I do feel like that, or my belief in the argument here is that a lot of the district court's mandates are not based on law that is binding. Now, see, my time is up. I'll be happy to see you.
Just ask one more question. I kind of took you off, on these Article 3 issues and some things right early on, and I felt like they were important. But give me your best argument as to why it was an abuse of discretion. I mean, obviously it keeps the case from being decided on the merits, but why is it an abuse of discretion when you've been given 2 opportunities? Is there a case, the best case, or something that says not just that they could have done it different, that it was an abuse of discretion?
And you're talking about the amendment?
Yeah, not granting the amendment.
Okay, so any abuse of discretion, within any abuse of discretion, any conclusions of law are still reviewed de novo. If a decision that is subject to abuse of discretion analysis is based on an error of law, then it is still reviewable, and it's still reviewable de novo. So we don't really have a good explanation within that order as to why amendment was denied, but if it's premised on the idea that inline exhibits are inappropriate, that's not the orders. If it's based on violation of the orders of the magistrate judge from earlier, all of those orders are not based on valid law. They're not based on Rule 8. They're based on a number of unreported decisions, really dealing with pro se litigants.
I got it. So your argument is that the decisions about original complaint and first amended complaint were wrong, and that infects the decision not to allow the third amended complait? Is that what
It
you're
does,
saying?
yes, Your Honor.
All right, I appreciate that.
Thank you.
I understand it.
Hold on a minute. As much as you may want to get off. The Federal Rules of Civil Procedure, right, it's generally the 30-somethings, give the district court a broad discretion to impose a variety of sanctions. They escalate, depend upon the severity of the offense. And some of them are for discovery and everything, but, and Rule 11 gives the district court a good bit of discretion with respect to a frivolous complaint. And so the combination of, I think it's Rule 11 and some of the other federal civil rules, would seem to accord the district court broad discretion when the court discerns an abuse of the judicial process here. And I've suggested that an abuse can be committed when there is an opaque mass of documents delivered to the curbside to the district court and ask the district judge and the defendant to frame the case for counsel. Why isn't the shift of responsibilities, in essence, from the plaintiff's attorney to the defense attorney and to the court itself? Why isn't that justify what the district court did? The district court dismissed this, I guess, without prejudice. It could well have dismissed it with prejudice. I mean, they're trying to hold the Attorney General liable in some way and dragging the Attorney General of South Carolina into court for issuing an advisory opinion. I mean, how can the district court have done anything wrong when you look at the record in its totality and the basic indecipherability of what was delivered to the trial judge? How can that be an abuse of discretion, sir?
Well, Your Honor, respectfully, I don't know if I wouldn't consider it indecipherable. It was long, it was complex. But unfortunately, I myself in practice have had to respond to complaints like this. It can be answered. You can answer this and move forward and get to discovery and then find out if it needs to be dealt with, if issues within it need to be dealt with. But if a plausible cause of action is set forth, and one of the reasons this complaint is so long and so complex is because of just what you said there. These are pretty serious allegations. You don't just walk into the courthouse with a 10-page bare bones complaint and say, oh, I think that the Attorney General's issuing secret advisory opinions that don't get published. No, you don't make allegations like that without showing up with a little bit of proof. Because that's when you're making a really serious allegation, show up with some serious proof. Show up with, as they say, the kids say these days, show up with the receipts. Because you will see, that's why you see these inline quotes from email after email. Why you see, especially in the first complaint, Why, you see large block quotes. Sometimes when you allege something serious like
Can
this,
you have 32 claims against how many defendants were there in the second amended complaint?
I cannot tell you the exact number off the top of my head.
Have what?
I can't tell you the exact number off the top of my head, Your Honor.
Well, you file the complaint, you should know exactly how many defendants are in the second amendment complaint.
I'll be happy to tell you exact. I was not trial counsel, but I can get you the exact number as soon as I sit down, and I'll be back up for a rebuttal soon.
I thought there were something like 32 defendants.
That sounds about correct, Your Honor.
I mean, there were 33 defendants. That was a deficiency that was pointed out in the first complaint. And the only cure that was made was the number of defendants were reduced from 33 to 32. And I don't know how many causes of action there might be, but you can't even tell me how many defendants there were in the complaint that you filed. And what's a district court supposed to do with that? And what are these 32 defendants supposed to do with that? If you can't tell me, how can they unravel it all?
They'll have the benefit of having the complaint in front of them. That's how they can respond to it.
All right. Thank you, sir.
Thank you.
Mr. Fowler?
I was checking to make sure it was still morning before saying good morning. So good morning to you. I appreciate the opportunity. Daniel Plyler here on behalf of most of the appellees. I do have Gene Matthews with me, who's going to be speaking specifically on behalf of the Attorney General's
Can you
office.
put the down, yeah, so we can all hear you?
Thank you, Your Honor. Sorry about that. I'm going to start with the fact that there is a record in this case, and the record in this case shows a continuing and repeated failure to follow the rules. These rules are in place to create an efficient process for litigants to come before the court and have matters decided. They're drafted in ways to ensure fairness to the opposing parties and to the court so that everybody's not wasting resources they don't have to, and that can be found in Rule 1. This particular complaint that started this whole process violated Rule 1, violated Rule 8, violated Rule 10, and as a result, was subject to dismissal under Rule 12. Instead of doing so, though, the district court gave the appellant an opportunity to file an amended complaint with clear guidelines of how to fix those deficiencies. They failed to do so.
So what do you do? I understand that argument. I want you to talk to Judge Quattlebaum's question about jurisdiction too, but what do you do with the argument I take your colleagues making on the other side that they didn't really know how to respond, or they weren't required to respond with a new complaint that excluded all evidentiary matters? I mean, that seems like a little bit of an unusual order for a court to give, is to say, we want you to exclude evidentiary matters, may not be embedded, which I take to mean included, in the complaint. I mean, that's a pretty unusual story, right? Most complaints include lots of evidence. That's the sort of point of having a complaint, is to explain what went wrong and how it went wrong and what the evidence is. That seems like a pretty unusual, order. And so, I take your colleagues' complaints to be like, we didn't really know what to do in that instance. Like, what do you mean remove all the evidence? And so, in that sense, they were between a rock and a hard place. What's the response to that?
So I think first off, I would like to say, I don't even think the court has to grapple with that issue, because one of the other rule violations here that's been done by appellant is a failure to follow Rule 72. So this was a non-dispositive order that you're speaking to.
I understand that argument. Go back to my question first.
Okay. So I think when you read that order in context, assuming the court gets to it, that what the court was saying was you can't embed these things. You can't take a screenshot of a portion of a document, slap it into a complaint, because that would violate Rule 10.
Why not? Why is that not the case? I mean, if I've got a contract case and it's got a provision that's the key provision, you really think the federal rules prohibit you from taking a screenshot of the actual contract provision and putting it in?
I do.
Or a photograph? You think the federal rules prohibit you from doing that?
I think it does, and if I could explain.
Why is that?
So
What
with
rule?
I'm sorry.
What rule?
So with Rule 10, which requires you to state and enumerate your allegations, that's Rule 10. And it's supposed to be as short and concise as possible and not get into multiple issues, because then that allows me to answer it. So let's say we're talking about paragraph 10 of your complaint. You make an allegation. I then answer paragraph 10 of your complaint and know exactly what I'm answering. But that's Rule 10. The rules also allow you to attach.
What if, I'm sorry to interrupt you, but what if instead of taking a screenshot, you quoted it? You just kept it in the regular text, but you quoted some portions of emails that were material to the claims. Is that a violation of the federal rules?
I don't believe that would be, provided that it complies with Rule 10 and stays concise and not mixing issues into paragraphs where we then have to parse out parts we're responding to and other parts that we're not responding to. And I did want to address, the rules allow you to attach exhibits. I mean, that's allowed. But when you start taking portions of a document, screenshotting it, putting it into a paragraph that's not enumerated, it makes the other side in a position of, well, how do I even respond to that? So that is a problem. I don't, with the risk of challenging your patience there, Judge Richardson, I don't want to give up the argument here that Rule 72A specifically says a party may not assign as error a defect in the order not timely objected to. And that's what happened here. They filed no objections to the magistrate's order, the first order in February 23, that decided that your complaint doesn't comply with Rule 8. The same thing happened with regards to the second order issued by the magistrate judge, which again tried to explain to the litigant how to properly plead a complaint that will satisfy Rule 8. They filed no objections to that at all. And as a result, they have waived their appellate review of those two decisions. So then you're stuck with the final order that was issued by Judge Hendricks, which finally said, you've already had 3 opportunities to file a complaint that satisfies the rules, and you failed to do so on 3 occasions: your original complaint, your first amended complaint, your second amended complaint. Judge Hendricks was then deciding between 2 recommendations that have been provided by the magistrate judge. The first recommendation is dismiss this case without prejudice. That was over our objection, by the way. We thought at that point it should have been dismissed with prejudice. There was an alternative recommendation, which is, Judge Hendricks, if you're not going to dismiss this case without prejudice, then make them file an amended complaint. That was the recommendation.
Well,
Judge
after
Hendricks.
the second amended complaint, the ultimate result was to dismiss without prejudice.
Correct. That's the recommendation that Judge Hendricks chose. That's the recommendation that Judge Hendricks
But
adopted.
I'm saying what the district court ultimately did. It was a dismissal without prejudice.
Correct. Based on
Would it
the.
be open to the Court of Appeals to remand with instructions to dismiss with prejudice?
We would be happy with that result, Your Honor. But I do want to touch on, I don't even think they
Can
preserved.
you, just in this context, can you tell us if you think it matters, the current July 2025 complaint that's been filed in the district court? Does that affect us in any way? We now have, it was without prejudice. Now the plaintiffs appear to have filed effectively the third amended complaint as an initial complaint from July of 2025. Does that affect us in any way, or what am I supposed to do with that?
I don't know that it affects what the analysis the court's being asked to make in this appeal. But I do want to point out that there is a motion to dismiss pending against that complaint as well. So it's not like the appellees in this particular appeal have conceded that the current filed amended complaint, by taking advantage of the without prejudice language of Judge Hendricks' order, somehow satisfied all these rules. But I do want to point out that they waived their appellate rights on that as well. So under the Magistrate Act and the associated rules that is part of the structure of the district court, you must file specific written objections or you waive your right to appellate review. And with the recommendation that was adopted by Judge Hendricks, which is you should dismiss this case without prejudice for failure to comply with the rules, they never filed specific written objections to that particular recommendation, which
Counsel,
waives their appellate review.
I think the plaintiffs have a lot of obstacles, including the Article 3 issues that you haven't addressed yet. I'm not criticizing that, by the way, but, yeah, and the abuse of discretion standard and all the things, preservation issues, but, yeah, we don't decide things for this reason. But there's some remarkable allegations that are clear in the complaint. I mean, there are allegations that immediately after a South Carolina judge says, do not destroy the property, there is a SLED plan for the destruction of property. And I know those are just allegations, they're not proof, I don't know the context or anything, but I mean, there's some stuff in there that's, eyebrow raising. And, maybe everything here lines up so that that never gets to be addressed in any way because of all the procedural things you're talking about. But, again, I just point out, we got to apply the law when we will, but, there's some concern about getting to the merits sometimes.
And Your Honor, if I can address the question kind of in the reverse order, so starting with what you said last and then trying to get to the Article 3. There's a state court case that was filed by this same litigant on this same factual nexus as far back as August of 21.
There are two, aren't they?
There's a separate case on a different factual nexus that has to do with another illegal crop that he was growing in Marion County, not in Dorchester County. This factual nexus all arises out of the Dorchester County situation. But they filed that case in August of 21. 13 months later is when they filed the federal case, or attempted to file the federal case, that repeatedly didn't comply with the rules. I bring that up because this court's decision in the case of, and I always pronounce this wrong, I think it's Glaser, and in the Glaser opinion, Glaser v. Enzo Biochem from 2006, there's a remarkably similar fact pattern. In that case, they were given 4 opportunities to amend. The complaint was plagued with prolixity. They hid allegations and
No,
just.
I don't think that anybody is contending that the length of a complaint alone is a reason to get rid of them, because there are a lot of long complaints. And there are a lot of complaints with multiple claims. And so you don't want to slide into a rule that says, oh, well, we have a per se rule, you can't go over this length, or you can't add this number of claims. But what happened here wasn't helpful, that there were 32 defendants and we don't know how many. And I asked, can you tell me how many? He can't even tell me how many.
You were correct, there's
defendants
32.
there are. That's not good. But the problem here was the absence of clarity and the obligation of a complaint to give notice. That's a basic due process obligation. You have to give notice to the people that you're dragging into court, why you got them in court, which cause of action is directed against which defendant. And you can't expect lawyers and judges to do what the plaintiff's job is. And it is a function not purely of length and not purely of the number of claims, but it is a function of due process notice, which inheres in the whole idea that when someone is taken to court, they are entitled to know why. And it is quite an undertaking in this instance to figure out why. That's the problem that I have, is that it's a sober act to drag someone into court. That is not something we ought to do every day and twice on Saturdays. When you take the solemn step of dragging somebody into court, you may win, you may lose, but at the outset, you have to let that person know. That's due process, and that has always seemed to me to be a component, even if unexpressed, in Rule 8 and in Iqbal Twombly and everything like that. What does plausibility mean? Well, in part, it means we'll give you notice as to why we think this claim is meritorious. But the whole idea of notice is embedded in our pleading standards, and that was the default.
I agree completely, Judge Wilkerson. That's the problem. This is not just a technical, you didn't check all the boxes sort of argument. It's the defendants each individually. And I would point out that in this case, we're talking about high-ranking governmental officials in South Carolina that are going to have to stop what they're doing long enough to assist their attorneys to try to make sense of these complaints. I mean, there's some qualified immunity type public policy things that you could bring into this as well. That we should not be burdened with having to decipher an indecipherable document.
You shouldn't have to do that.
Correct. And I agree with you wholeheartedly. I brought up the Glacier case, if I may, only to point out that in 2006, this court was faced with a very similar sort of situation. And one of the things it pointed out was you had 13 months in the Glacier case. It happens to be the exact same amount of time. You had 13 months to discover all you wanted to through a bankruptcy proceeding, what the facts were, start organizing how it connects each defendant, and bring a pleading that complies with the rules, and you failed to do so. And in that case, the result was a dismissal with prejudice. The litigants in that case also argued the same thing that you're hearing from the appellant, which is, but just give us another opportunity to amend. Well, and this court found that it was not an abuse of discretion to deny them yet another opportunity to amend, and that's rooted in the U.S. Supreme Court case of Foman v. Davis, where this court, where they recognize that one of the reasons you can deny a motion to amend, or for leave to amend, excuse me, is when there's been repeated failures to cure these deficiencies despite previous amendments.
Can you just take a little bit before your time is totally over to address Judge Quattlebaum's Article 3 concern, not just with respect to the AG defendants? I know your colleague is going to talk more about them, but based on the Second amended complaint, that there's no allegations that would provide for jurisdiction at all?
I know that jurisdictional issues can be raised at any point in the proceedings because they go to the bedrock of whether or not this court can consider that. I think when you consider this entire case in its totality, there are multiple places where you can take that off-ramp, that there is no jurisdiction, or you have waived your rights for an appellate review, you didn't preserve it because you never filed a motion for leave to amend. I do think my colleague is going to have more on the Article 3 question, so I would cede that to him if that's okay. But if I see my time is also up. If there's any additional questions, though, I'm happy to answer it. Thank you.
Thank you. Mr. Matthews?
Your Honors, thank you for permitting the AG to be heard in addition to the other defendants. My name is Gene Matthews, and I represent what we'll call the AG appellees in this case. We come here first. There were two instances in both the one in the final report and recommendation, one in the Judge Hendricks' final order, where she footnotes our specific pleadings with regard to immunity primarily, but also standing, in addition to just the basic defects we thought were with the substantive pleadings. That's at JA 341 and JA 393. So that gives you grounds to affirm or remand with instructions on viable alternative grounds that Judge Hendricks enunciated. And while we argued strongly at the trial level that she should have dismissed with prejudice, we understood her footnote in her order that, and I think this echoes one of your questions, dismissal without prejudice doesn't mean without consequence. And I believe that was with an eye toward statutes of limitations. So I think I understood where Judge Hendricks was going with that. I don't really have an objection to that. To the extent we have an objection, if you want to call it that, we do think that the judge should have wrestled with and addressed some bedrock principles that we have, especially with regard to the AG's role.
But could you just kind of write it? I mean, we appreciate the AG specific Article 3, and we want to hear that. But
yes, sir.
what about the second amended complaint as the operative complaint now, whether it's the AG or any of the defendants? Is there Article III jurisdiction?
Well, Your Honor, we would argue no. And the reason is we have a difficult time understanding the injury in fact and the redressability.
Well, they seem to be, that your colleague says we, I think, can look at the record, which contains information that might provide it. And so, on that issue alone, do you agree or disagree?
No, sir, I don't at all. And I believe I second Judge Hendricks on the point, and frankly, I believe Judge Cherry was the magistrate. I believe they both indicated, and I believe this very bench has, that once you amend your complaint, nullities are nullities, period.
So, let's assume there's no jurisdiction, Article III jurisdiction for any defendants under the second amended complaint.
Yes, sir.
There's a following question about whether we could, whether the court could consider a motion to amend the pleading if the operative complaint doesn't state Article III jurisdiction. There's a circuit split on that. That's not really briefed. I'm not trying to hit you with a curveball on that.
Thank you.
There's no Fourth Circuit, well, it's questionable what Fourth, you may not be prepared on that, but we may or may not be able to consider the amended complaint even if there is no jurisdiction. Do you have a position on whether we can or can't?
Well, I would adopt, frankly, the argument that that's well within the court's, the Judge Hendricks' discretion.
So, but normally, I mean, the counter with that, if we don't have power, the court doesn't have power, it doesn't have power.
Yes, sir, but the only prayer that the appellants would have is if she did have that authority, or if they now want to convince you to exercise that as if she had abused her discretion. And that's not true. She did not abuse her discretion. If anything, I was astounded. I was actually one of the attorneys litigating at the trial level, and was astounded, frankly, that the court showed such patience with the plaintiffs. The first, the first bite at the apple was the complaint itself, okay, and it was not sufficient for the reasons you're well familiar with. Then there was a First Amendment complaint, the second bite at the apple, which, okay, we didn't like that, but okay, they got a chance. The third bite at the apple is the one that, Your Honor, that you're referring to, the second complaint, and it was as defective as the others, but for reasons Judge Wilkinson indicated, to the opposite way. The things
I think the point you make is a good one here. This district court showed a great deal of patience here.
extraordinary patience, and frankly, we wish that she had not, but she did, and she's the judge.
I understand, but it's hard for me to say that a district court which acted with admirable patience somehow abused its discretion. And what she was presented with, when you read all of these different documents, she was presented with a muddle.
Yes, Your Honor.
A complete muddle, and it's not something you kick out of court on the basis of whether you've exceeded the required number or whatever. I come back to the basic point that it is a question of notice to the defendant and also to the court, and that the obligation to give notice is transgressed when you present the defendant and you present the court with a total muddle. And that was what was done here.
And Your Honor, you had asked an earlier question. There was, I think, 33 defendants in the first complaint, 32 in the second. The one defendant that was excluded was an administrative assistant at the AG's office, whose name appeared somewhere on a CC line on an email. But that was the only person excluded from the First Amendment complaint that was also in the original complaint. Your Honors, I see that my time is long
Time has
since.
elapsed, and so unless you have a very brief conclusion, I'll ask.
Then, Your Honors, let me commend the brief to you, especially what we really want, what the AG really wants, I believe, the reason I'm up here. There is an opportunity here to educate bench and bar about immunities specific to prosecutors and their staff. And if you remember nothing else from what I've said here, please remember this, or please hear this plea to the court. Especially the absolute immunity that attends to quasi-judicial roles of the AG, like issuing advisory opinions, specifically to that, or even discussing whether or not the AG's office is going to assist a state official in litigation. I notice a mistake in their pleading. The AG has not been sued in state court.
I understand your point, and that is that AGs issue advisory opinions all the time, every day in a week, and that they cannot be dragged into court because someone disagrees maybe with this advisory opinion or that, or they'd be doing absolutely nothing but litigating. And what I think it's phrased is the advisory opinion, it's not a pure adjudicative act, but it is an adjudicative act. And as a result, you would like there to be a grant of quasi-judicial immunity to attorneys general when they issue an advisory opinion, which
Exactly.
is what they do is what their day-to-day job is all about.
Exactly, Your Honor, and indeed, the South Carolina Supreme Court has already accorded quasi-judicial.
Too many people are being dragged into court in this case for too many infirm reasons.
Yes, Your Honor. Thank you. And if there are no other questions, I'm happy to sit. Thank you.
Mr. Luck, you have some rebuttal time, sir.
Thank you, Your Honor. And so the invocation of Rule 1, I think, is apt here. And Rule 1, Rules of Civil Procedure, that pleadings are to be construed to do justice. And so if there is a situation here where there is, as Judge Wilkinson has said, a muddle, if that is present in the first and second complaints, it's not from a result of a bad faith act. These are good faith attempts to correct, good faith attempts to course correct. First amended complaint, second amended complaint. We've barely talked about the contents of the third amended complaint.
Do you think it depends on good faith? So if we were to find, I mean, you just said that. It didn't strike me that was relevant. Like good faith incompetence versus bad faith competence. I'm not sure why that would matter. I mean, if we thought, I'm not saying that we do, but if we thought that they were, inadequate for incompetence rather than inadequate for bad faith, why would that matter?
Well, when you're trying to respond to an order that is less than clear, if you're trying to pare down a complaint based on law that doesn't necessarily support paring a complaint down, you respond to it the best you can. It's bad faith is when you're filing these complaints to delay, to cause trouble, to just for any reason other than trying to get to the heart of the matter. That's sanctionable. That's terrible. And for that, Judge Wilkinson, I agree, that's a terrible thing to do. That's when someone takes advantage of the court in bad faith. But when someone in good faith tries to comply with an order and is constantly knocked back, that's not a reason to prevent their client from seeing some form of relief. And we have the means to do that here in this case, in this appeal, through the filing of that third amended complaint. We haven't talked about it much because it really does fix the alleged infirmities of the prior complaints. The relief is there. We just need to, we as a court, we as a society, we need to come together and find a way to get to the filing of this complaint and just proceed with discovery. Now, there are other lawsuits, yes. There, mentioned earlier, a case in Marion County. That was a injunctive relief case that was brought because my client had heard through the grapevine that there was another seizure taking place. And bear in mind, you never received notice or opportunity to be heard regarding these
You
seizures.
understand that we're not taking lightly the property rights that you assert. We're not making any judgment on that. We're not making any judgment about the value of your claim or the sincerity that you feel with regard to your property and what's being done to it. This is purely a matter of having you present your claim in a way that would actually end up affording you a chance of success. It's not a question of we disparage your claim. That is not what we're doing. That is not what I'm doing. It's the fact that you have a much better chance of succeeding in what are obviously heartfelt situation. If there is some clarity and in the presentation of your grievances, then they can go forward. But this is not it's not a mark of, in any way, of disrespect toward what you feel has been done to your property, okay?
I believe you. Yes, Your Honor, I know that.
It is a matter of presenting your claim in a way that maximizes its chance of a respectful hearing on the merits, okay?
Yes, Your Honor.
That's just me. Other people have all sorts of different views, but that's just me.
Well, what we have, it's an opportunity, is what it is. We have spent quite a long time up here talking about pleading standards. It's not something we see a lot of case law on in the circuit. It's an opportunity to clarify that and make sure that
the problems, the procedures exist for a reason, and one of the reasons, is that when you don't like what a magistrate has done, you need to file objections, and there needs to be that we're up here on an abuse of discretion standard, and there are all kinds of procedural hurdles or conceivable jurisdictional problems and everything, but hopefully those kinds of things can be avoided from here on out.
as appellant's counsel, this is something that I very frequently have to navigate, especially when I take up a case that someone else handled on trial level. It makes it more challenging, though. That doesn't make the relief any more or less warranted, because the relief is necessary, but it does make the path getting there a lot less straight, and that's the fun part of it.
Nobody loves procedural tripwires, and I'm sure you think that these are procedural landmines and they're tripwires and they're hard to navigate, and I understand that, but I do think that the opposing counsel made a very persuasive argument, and that was that the district judge showed here a lot of commendable patience. And it's hard to reverse somebody for abuse of their office or the discretion bestowed by their office when they have been as patient as this district judge was here. That's just a simple point.
Well, thank you, Your Honor. Yes, she was very patient, and she's very competent, but it doesn't mean that she didn't make a mistake here. And that's,
okay.
Even the best of us make mistakes. And I see my time isn't up, but I think it's up, and we all need to go home for Christmas, don't we? Thank you, Your Honor.
We thank you, sir, and we will adjourn court, and we'll come down and agree counsel.
This honorable court stands adjourned, sign and die. God save the United States and this honorable court.